The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh to give their attention, for the court is now sitting. God save the United States and this honorable court.
Ms. Bourne.
You ready for me?
Absolutely.
Just making sure. Ready to be set. Good morning, Your Honors. Renee Bowen on behalf of
Good morning.
Great Dedicated Transport. I'm going to assume that you all are familiar with the facts unless you tell me otherwise, because we've got a lot to get through. So I wanted to get straight to the arguments here. So this is an appeal from the administrative agency, the Department of Labor's Administrative Review Board, for an alleged wrongful discharge under the Surface Transportation Assistance Act, the STAA. And there are three primary issues that I want to discuss today. There are some sub issues under those categories, but the primary issues are there was a valid and enforceable settlement agreement between the parties that the ALJ and the ARB refused to address. The second issue is that there were significant and prejudicial delays in the administrative proceedings that caused Great-wide severe prejudice in putting on their case. And the third issue is that the ALJ's findings and the ARB's adoption of those findings were not supported by substantial evidence in the record. So I'll address each of those in turn. The first issue I want to discuss is the settlement agreement, because that is a threshold issue. This case should never have been submitted to an evidentiary hearing in the first place. The parties reached a binding and enforceable settlement agreement that was extensively negotiated. And as part of the joint appendix, we have the motion to enforce the settlement agreement that was filed, and that's at page 148 of the joint appendix. And the ALJ refused to hear any evidence on the issue. He wouldn't let us bring it up. He refused to discuss.
Because he said he didn't have jurisdiction to enforce the settlement agreement. And did you challenge that conclusion in front of the ARB?
We did not.
Well, then how is it in front of us?
I'm sorry?
Then why is it in front of us?
So it was an issue that was, so under 29 CFR 1978.110A, the regulation does not automatically deem something that's not raised in a petition to the ARB as waived. It says it may be waived, but it doesn't require it to be waived. In this instance, it's not waived because it formed a part of the ARB's decision and order. They specifically in their decision referenced Great-wide settlement position and specifically found that there was substantial evidence in the record that the parties did not enter into a settlement agreement. So that formed a
But the enforceability, you're raising a legal question, right, about whether the ALJ has the authority, jurisdiction to enforce a settlement agreement. And that question was never presented to the board or ruled on by the board. And I just am struggling to figure out how we would address it in the first instance.
Sure. So it was the legal question as to whether or not there was enforceability is part of the issue as to whether or not there was substantial evidence to support it, because that was what the ARB ruled. They ruled there was not substantial evidence. And that is because when we tried to bring it up at the hearing, the ALJ said, I believe his exact words were full stop on that one. He would not let us put any evidence in with respect to the settlement agreement. So the ARB took the record and said that there was not substantial evidence to support that there was a settlement agreement. And that's because there was nothing in the record because we weren't allowed to present evidence on that issue. And the ALJ erred in not permitting us to address the issue, stayed on the basis that he doesn't have authority to enforce a settlement agreement, but that's incorrect. So if you look at the motion to enforce settlement agreement, what we requested was a dismissal of the complaint because of the settlement. And the ALJ, there's an ARB case, an administrative review board case that is directly on point. It's Tankersley v. Triple Crown Services, and the Office of the Administrative Law Judge's case number is 92-STA8. And in that case, there was an oral settlement agreement reached by the parties. The complainant subsequently refused to sign the written agreement, and on motion that to enforce or approve the settlement, the oral settlement agreement, in that case, the ALJ was permitted and had the authority to receive evidence to determine whether a settlement agreement existed, and if it did, to approve the settlement and dismiss the case. That's all we were asking for, whether it was titled a motion to enforce. The relief that was sought was dismissal of the case based on this settlement. So the ALJ erred in refusing to allow that evidence in the evidentiary hearing and refusing to address that motion, that preliminary motion. So on that basis, that's just an incorrect legal conclusion that they didn't have the authority to do that, and I believe it was preserved because the ARB addressed it as a basis of their decision. So the second issue I'm just going to address briefly is,
before you go to the second issue, assuming that you get past the hurdle of whether or not it's appropriately reserved for our review, that you have a contract. You know, the old expression is the devil is in the detail. Do you have the detail assigned on by both parties?
I'm sorry,
The detail, like other things, you know, like otherwise a lot of people look at the gross state amount, perhaps, for example, but there are other details. Weren't they added later? And
so no. So that is there were two provisions that Mr. Huang complained about as that were seen as additional material terms in that settlement agreement. They were not additional material terms. Those two terms were confidentiality and a release.
that's not material?
So so it's not, because the ARB routinely severs confidentiality provisions from these types of agreements. They said, and I agreed with Mr. Stady that should be taken out of the agreement because it has no practical effect, and it wasn't actually agreed to. I agreed to that. So that would have been taken out by the ARB because the ARB, the Department of Labor, requires these settlement agreements to be in writing, and it becomes part of the public record and subject to Freedom of Information Act requests. And so they've routinely found, and there's a couple of cases where they discussed that when settlement agreements are provided to them, written agreements are provided to them with a confidentiality provision, they just sever them and approve the rest of the settlement.
So your position is, because the provision that you added has no practical effect and he objected, that doesn't preclude him from looking at the agreement as a whole?
So that was the only provision that they contested, that and the fact that Mr. Huang released his claims was the only provision that he challenged. And I agreed with him when Mr. Stady came back to me and said, hey, there was no agreement to confidentiality. I said, you know what, you're right. I'll take that out. This was my standard employment release that I generally use, that I sent over. And so I agreed, that's not part of the agreement. So that doesn't change the fact that there was an agreement reached on the material terms. what the terms were that Mr. Huang agreed to release his complaint on. So it's not material because it would have had no impact on the actual agreement that was approved by the secretary. They just would have severed it from the agreement.
Well,
We weren't claiming it was.
let's go to the major part of it, since you explained why you think the rest is boilerplate and would have been removed. He said, I think I'm ready to settle, if it's available. Isn't that conditional language on both of those? I think if it's available, you think together because it's available, that made the think an automatic expression of a contract?
So he said, I think, yeah, we're going to go with the settlement if it's still available. I confirmed in writing that it was still available and the terms. So that was, but quite honestly, that's the way Mr. Huang speaks. I know that's not in the record. He's very equivocal. And he does say, I think we're going to accept settlement if it's still available. I don't have the exact language.
So I say so you want us to interpret, I think equates to I'm going to do it.
That is what it was extensive negotiations. I think we're going to do it.
I have the language. I know the language.
Okay, and so the rest of that statement was that, put in the letter to the judge because the judge requested updates on settlement, that we intended to file for dismissal. And he hoped we didn't have to go through that because he is now accepting the settlement. When you look at the entire voicemail as a whole, it shows that he agreed to that settlement. The ALJ was required to take evidence to determine whether or not there was a valid settlement agreement under the Tankersley case. He did not do that. If there was any ambiguity there, he was required to receive evidence and hear argument on that, and he did not. So that is a clear error on the part of the ALJ and the ARB.
How is it an error on part of the ARB if you didn't make this argument to the ARB? I don't understand. In what respect did the ARB err by not considering whether or not the ALJ was wrong when the ALJ decided not to take evidence because the ALJ couldn't enforce your settlement agreement anyway?
So it's a clear error on the part of the ARB because they reviewed the record to see if—
Right, which is a different question. They didn't make a mistake in not ruling that, look, the ALJ should have taken evidence on this. The ALJ was wrong to think he couldn't enforce this agreement because you didn't tell the board that that was wrong.
Well, he said, and the ARB said in determining that in issuing their order, that there was substantial evidence.
Which is a different question. The thing that you think the ALJ got wrong is not something that you told the board the ALJ got wrong. You never told the board the ALJ was wrong in thinking he had no power to enforce this agreement and moving on.
So the question is whether or not it's supported by substantial evidence. And there was no evidence in the record because it was not permitted. And so the ARB went out of its way to find that there was no substantial evidence. So they raised that question, the ARB, and so it was not waived because the ARB discussed it. And the reason that there was no substantial evidence in the record was because we were not permitted to introduce it. So had we been permitted to introduce it, then there would have been substantial evidence in the record, and the ARB erred in that conclusion based on the underlying circumstances. So that the other issue that I want to address just very briefly is the substantial delays in the administrative proceedings. And the timeline is all laid out in our briefs, and I will defer to that. However, the ALJ found that these extensive delays were not prejudicial to Great Wide, and that there was because there were 3 great white witnesses who were able to testify at the hearing. However, there was clear evidence in the record that all 3 of those great white witnesses, Mr. Burnett, Mr. Scott, and Ms. Price, couldn't recall key details on key.
Can I ask you what I think is sort of a threshold question, almost before we get to the question of prejudice? So as I understand the timeline, what you are concerned about, because it goes to prejudice, it's mostly really the 3.5 years it took OSHA to resolve this complaint, right? And there's no contention that the employee here had anything to do with that delay. And so I guess I'm asking, is there any authority for the idea that we would effectively punish an employee who prevails before an agency because the agency took too long to give him relief? Like, how would that make sense?
So the employee.
Is there any case that's ever done that?
There's no case, but the statute itself, the statute itself, or 49 USC 31105C, if the agency, if the secretary does not issue that decision by day 210, that after their 60 days that they're supposed to, the employee has the option of filing in district court as opposed to waiting for the agency decision. That is not an option that the employer has. So the delay is in part caused by Mr. Huang's failure to expedite the proceedings. Now, there was a lot of argument in the briefs about
But that's just an opportunity. That's not an obligation under the regulations for the employee to do that, is it?
it is not an obligation. No,
So how is it his fault if he doesn't do something that is not obligated to do?
I'm not saying that he, that he had an obligation to do that, but he had that option and he was the only one who had that option. So it took a significant period of time, and that delay that's not attributable to Mr. Huang. I agree. That is the secretary, the Department of Labor. But Mr. Huang did have the option to expedite these proceedings, whereas Great White did not. And that's all that I'm saying based on that
Right.
statute.
But there's nothing, I think this is sort of an interesting question, but I could not find any case that supported the idea that if an employee, was hurt as much as anyone by this, it took him an extra 7 years or something to get his back pay award, that we would then turn around and take away the back pay award because the agency took too long in getting him his relief. It just seems very counterintuitive, and I couldn't find any case suggesting that that would be sort of an appropriate response.
So if there is prejudice, something prejudice, then they are outlined. They're outlined in the brief. If there is prejudice caused by the delay, substantial prejudice, then they can dismiss the case.
But that's a case where, well, I'm guessing you're thinking of the same case as I found, where the agency is bringing the claim. And then it sort of makes sense to say, look, agency government, you took too long. Now you can't proceed with your claim. I couldn't find anything where it's an individual employee being penalized because an entirely different actor, the agency, took too long. But maybe if you've got a case, I'll look again.
The same kind of it's based on the same what word am I looking for? The same premise is that the significant delays prejudice the defendant in those cases. And here, nothing can highlight the prejudice more than the ALJ's decision, citing what he calls as inconsistencies in some of the witness testimony. They weren't actually inconsistencies. The testimony built upon each other. It wasn't differing, but some of the witnesses, they remembered things in more detail than others. And that's because of the passage of time. And they're on all 3, Burnett, Scott, and Price, testified that they had trouble recalling key details because of the passage.
Guys, why didn't your client, once the employee filed very promptly his OSHA complaint, wasn't OSHA, I'm sorry, filed his whistleblower complaint, why didn't the employer immediately get everyone's testimony on the record? Like, you were on notice, there's going to be this complaint, so gather your people, do an investigation, figure out what happened and memorialize it so that however many years later, everybody will know what happened.
I don't have an answer to that question. People don't go through life thinking that they're going to be involved in litigation.
Right, but once the complaint is filed, it's pretty clear they're going to be involved in litigation. They are.
They are. They did not see any merit to the claims. And so they preserved the documents that were relevant to the discharge. They preserved the meeting minutes. They preserved some of the photographs. They preserved Mr. Huang's letters, which they found germane to the issue of his discharge. So they did preserve. So they preserved relevant documents. They didn't take testimony. They also weren't expecting it to be 5.5 years between the time of the filing and the evidentiary hearing, because the statute says 60 days. So that was not something that they were on notice that they needed to do at that
But
point.
it's some.
And in addition, Ms. Price, who was the safety director and also involved in the decision to terminate, she left Great Wide about 3 or 4 months later to take a new opportunity. So she wasn't employed by Great Wide for an extensive period of time, or for a period of time after the complaint was filed. She was not in their control at that point to be able to get testimony, or even if they were to go and preserve testimony. When we get to the actual substantive issues, we have significant issues with the ALJ's and the ARB's decision regarding substantial, that the findings were supported by substantial evidence in the record. Huang had the burden of proving 3 things in his case, and that was that he engaged in protected activity. We don't dispute that he engaged in some protected activity. We do dispute the extent of what was protected, but we don't dispute that he did engage in some protected activity. We also don't dispute that there was an adverse employment action. He was terminated. Don't dispute that. Where we have a strong dispute is the contributing factor portion of that. The ALJ and the Administrative Review Board based their finding or found that Huang's protected activity was writing an anonymous letter alleging safety issues or safety complaints. We don't dispute that was protected activity. They also found that copying and removing confidential paperwork was protected activity. And they also found that recording conversations, confidential conversations, was protected activity. We do dispute those 2 things. However, our dispute with respect to those 2 are outlined in a lot of detail in our brief. For purposes of today, I don't think that it matters. So I'm going to assume we are not conceding the issue at all. But even if you were to agree that the recordings and the removal and copying of confidential paperwork was protected, it still doesn't affect the outcome. The ALJ did not find that dropping a trailer unattended on a Manhattan street unsecured was protected activity, and because that does not involve a safety complaint, and they did not find that damaging.
I'm sorry, just logically, I know you're way over time, but I'm a little bit, I didn't quite follow that. If we assume that the making of the recording and the taking the document out of the lockbox are protected activity, didn't the employer say that's why it fired him?
So in terms of the contributing factor analysis, they did not say that was why they fired him. There were 4 grounds for termination, each of which were independent of
Okay,
each other.
But
So-
if you fire, so you're saying, I understand what you're saying. So it takes care of contribute, like, obviously they said that's why they fired him, but if they would have fired him for the trailer thing anyway, it doesn't matter. Okay,
Correct,
Okay.
because the key portion of that contributing factor standard is if the protected activity alone or in combination affected the termination in some
so
way.
it takes care of, so now we're past contributing factor. For purposes of this argument, we are past contributing factor. That's what confused me. I thought that's where you wanted to kind of stand your ground today, but no, we're up to the fourth factor now.
Right, so,
Okay.
and I mean, if anybody has any questions about why, why we don't believe they're recording the
No,
conversation.
I don't.
I'm happy to address those. But again, it's, we'll defer to our brief on those two issues. So when you consider a contributing factor, because each of the grounds for termination were independent and would have been Huang would have been terminated in the absence of any other activity, you're looking at all of these individually. That is not by definition a contributing factor because the outcome would have been the same, so they did not affect the termination. In finding, then we get to the ALJ and the ARB's finding that Great Wide did not meet its burden to prove by clear and convincing evidence that it would have terminated Huang absent any protected activity. And the basis for that decision was what I touched on it earlier. The ALJ characterized as inconsistencies in the Great Wide testimony, Great Wide Witness's testimony about the reasons for the termination. And again, there was no inconsistency there. They built upon each other and recalled in more detail. Some recalled more detail than others. The letter of termination did not give a grounds for termination. That's not inconsistent with anything. It was just a notification of termination.
It's strange, but maybe not inconsistent.
And that's a policy. I've seen many letters of termination that just say you are hereby being terminated. When it was relayed to Mr. Huang by the HR representative, Ms. Harvey, Mr. Huang testified that she was informed of the reason for his termination, which was violations of violations of Great Wide policy. And that's not inconsistent because the day before his termination, he had a lengthy meeting with Great Wide officials in which they discussed the policies that he violated. And that meeting is memorialized in what was Respondents Exhibit F at the hearing, which was Mr. Jeff Lester's meeting minutes. Now, Huang at the hearing testified that the trailer drop issue was discussed at that meeting, that removing and copying documents was discussed at that meeting. And the letter also, or the meeting minutes also go into the damaging of the lockbox. Mr. Huang testified that he did not agree with the way that it was presented in Mr.
Excuse me, Ms. Bourne, you're way over time, but I'm trying to give you the time, but let's go back to this. Judge Harris, based on Judge Harris' questions and your answers, we'll peel the onion down to you're left with the one that had nothing to do with whether or not it was protected is the trailer left in Manhattan when he went to New Jersey, correct? Is that the only thing left? Because the lockbox is related to, isn't it removing, isn't that has some relationship to, you didn't bring a picture of that, right? I mean, in other words, if the lockbox was the piece de resistance, Charles, you didn't have a picture of it. Some people say it was enough to get a finger in or a hand, and other people say, no, you could get a grapefruit in it. I mean, so it didn't seem like that was really a big thing. But the trailer seems to be plausibly work-connected safety and property and protection. But what the problem is that you didn't even have evidence that sort of nailed that down as to did Nordstrom's people complain about it and make that, and it was very sketchy, right?
So it wasn't, because Mr. Scott testified that he communicated with the Nordstrom employee who reported that this was left unsecured. And Mr. Huang himself admitted that he left the trailer on the Manhattan street. Now there's a
Because he couldn't get it through the tow.
no, that was New Jersey. And that was the New Jersey terminal, not the Manhattan street.
So the tunnel had nothing to do with it in his explanation?
He testified a lot about the tunnel, but what is important there is that in order to get through that tunnel,
Yeah.
you have to drop the trailer on Nordstrom property. And the location where something is dropped is what makes it unsecure. It is the policy not to drop a trailer.
Counsel, I'm sorry,
Go ahead.
I feel like we are the ALJ, right? Like, it seems to me we are having right now a very interesting de novo discussion about what really happened here, but we're not. Like, we're reviewing 2 layers of administrative review for substantial evidence. And is there something, like, do you have an argument to make about that? Like, imagine that our review is not de novo. Imagine that we give great deference to what the agency already has heard, all of this evidence already found. Why wouldn't we say there's, it must have been a very interesting evidentiary hearing, but this is how the agency came out. I mean, I've read both opinions. I can't see the thing that they got so obviously wrong that I could say, no reasonable fact finder could come out this way. Do you have an argument to make about that?
Yes. So with respect to the substantial evidence, Huang's testimony himself, so starting with Huang's testimony, there was no actual evidence. His testimony was based on speculation, his beliefs, and that is throughout the record. When you get to the issue of the ALJ in deciding that there was that Great Wide did not meet its burden, found that relied on the fact that it was unclear as to where the trailer was left. The trailer was dropped. And that's not the issue. He completely missed the issue. The issue is where it was dropped. It doesn't matter if he went to New Jersey. It doesn't matter if he went around the corner. The issue is that it was dropped at the undisputed evidence, which is admitted to by Huang. Everybody agrees he dropped the trailer on a Manhattan street. And dropping the trailer means unhooking it. The testimony was unhooking it from the tractor and driving away. You're leaving a trailer, $5 million in merchandise on a street in Manhattan unattended. That was the basis for termination. He said there was and the testimony was in this case, by both Price and Scott, that he would have been terminated for that alone. And he was terminated for that alone. There was no dispute about that. Huang acknowledged that it was a company policy. The only evidence on this issue is that in the record is that he dropped the trailer on a Manhattan street and left it. Again, where he went is irrelevant. That is a clear violation of company policy that all of the witnesses testified is an independent grounds for termination, and he would have been terminated for that absent any other activity. So there was clear error. The ALJ ignored the actual evidence in this case on that issue and focused in on the fact that he determined it was unclear whether or not Mr. Huang went to New Jersey. That's irrelevant to the fact that he's admitted that he's dropped this trailer. There was also evidence that he would have been terminated for this sooner because he admitted to dropping trailers before, had Great Wide known about it. Great Wide did not know about these prior instances. So this is the temporal proximity between all of these events and the termination. It's it's irrelevant at this point because we have this intervening factor right before his termination that he was suspended right after that incident when Great White was notified about it. So in terms of the substantial evidence and the clear and convincing evidence, the only evidence in this case, clearly and unequivocally, when the ALJ himself asked Mr. Scott, would Mr. Huang have been terminated absent the recordings, the anonymous complaints, anything like that? He said unequivocally yes for the dropping of the trailer so he would have been terminated. And that's the only evidence on that issue. So I know I'm well over time. There were a lot of questions. Does anybody else have any additional questions on that I can help clarify before I sit down?
Thank you, Ms. Bowen. Ms. McInnes?
Thank you, judges. May it please the court, my name is Stephanie McInnes, and I'm arguing on behalf of the Department of Labor. Your honors, in this case, both the administrative law judge and the administrative review board in a per curiam decision agree that Mr. Huang proved by a preponderance of the evidence that he engaged in activity that was protected by the whistleblower provision of the Surface Transportation Assistance Act, and that this activity was a contributing factor to his termination. The ALJ and board also agree that Great White failed to prove its affirmative defense by clear and convincing evidence that it would have fired Mr. Huang absent that protected activity. Both are factual issues where the ALJ had to assess the evidence and make credibility determinations, and therefore on these issues, the court must now determine whether the ALJ and the ARB decisions were supported by substantial evidence in the record. Next, the court must assess whether the ARB was arbitrary and capricious or not in accordance with law in denying Great White's numerous procedural arguments. First, I'm going to start with the contributing factor and affirmative defense arguments that opposing counsel brought up. Judge Harris, I heard some confusion in some of the questioning, and I agree with where that's coming from because I think there's some confusion around what is the contributing factor analysis and what is related to the affirmative defense of there being this alternate, legitimate, non-discriminatory reason.
But do you agree that this, as you call it, an alternate affirmative defense, do you agree that if there was another reason that was not related to protective activity, if they could show that that alone was enough to justify the adverse action, that would be sufficient?
Correct.
So you concede, if, I'm not saying you concede that it's enough, but you do concede that they have that affirmative defense, that would be enough to, that they would prevail, correct?
Yes, correct, Your Honor.
Well, let's get to then, if you would, if you don't mind, since we sort of peel the onion to that point. Could you respond to the factual question, that is, as to substantial evidence? As I understand it, if they say that the only issue was, did he drop the trailer in Manhattan on a street? That's the only issue. Whether or not the reason for him not being able to get in the tunnel had nothing to do with it. I'll frame it. Tell us why there was substantial evidence against that factual proposition, that that was the rule of the company and that he admits that he violated it.
Well, Your Honor, as an initial matter, I would just like to point out that at the trial level, they would have the burden to show by clear and convincing evidence as part of their affirmative defense. So but
it can be shown through your testimony of the employee too. If he admits to the activity, you don't have to have anything external to his admission.
Sure, if Great White had proven by clear and convincing evidence.
But I want you to address that. Is it true that he admitted that he dropped the trailer in New York, in Manhattan on the street?
The decision is unclear on whether or not he dropped the trailer and.
The decision is, don't we have a record of what he said? What did he say? Did he, wait a minute, I must be speaking another language. Did he admit that he dropped the trailer in Manhattan on the street?
My understanding is that Great White argues that he did.
Okay, then, okay. He didn't, so he didn't, right?
He did
So
admit
what-
to dropping trailers previously.
But not that day.
That's my understanding of the record, yes.
Why did they find the trailer on the street?
I don't believe so. Maybe I misread the record, but my understanding of the record is that Great White argued that Mr. Wang in different places admitted to it, but the ALJ ultimately concluded that whether or not he was allowed to drop the trailer was unclear, whether or not it happened was unclear, whether or not it was against policy or if this was a regular practice of you can drop the trailer to use the restroom. All of that was factually unclear.
Counsel, I thought, actually trying to go back and find it and I can't, but I thought that the board basically said whether he dropped it or not, what they haven't been able to show is that they would have fired him for dropping it under these circumstances. Like even, right, I thought it's not enough to show that they could have fired him for this. They have to show, am I right, that they would have fired him for this? And I thought that's what the board said, that's the part where they hadn't shown that, what you just said about lunch breaks, like it wasn't obvious that when people drop a trailer just for a little bit, they actually do get fired, that they would have fired him for that.
That's correct, Your Honor. So that was part of the decision. Both decisions was that both what Great White's policy was regarding drop trailers was unclear, whether or not Mr. Wang had been they had shared that policy with him was unclear. It's also unclear what, if any, punishment would happen. And there's some evidence in the record that references, truck stops and those types of things where you would assume.
Concern here, right, is that you can have an employer with a handbook that says like you can't do anything, and they never enforce it. Everybody understands that, and then when the whistleblower shows up, they're like, "Hang on, we found something you did wrong. We've never enforced it before, but now we're going to fire you." I think that's why the board is focused on this question, not so much exactly what did he do, but can the company prove by clear and convincing evidence that people who do that, whatever their handbook may say, actually get fired? And I thought that was where the board thought you haven't made your showing.
That's correct. They made that point. Yes, that is correct. The only thing that I brought up in addition was that the policy itself was unclear. So both whether or not he could do it and then whether or not he would be fired are kind of two distinct points, and they held on both issues.
Counsel, it may not matter in this case if, we agree that prejudice hasn't been shown, but the delays in this case are staggering. I mean, and even though one argued, they clearly implicated interest. And what's the agency's position given the mandatory timeline as to how this could possibly take the amount of time that it took?
Your Honor, I don't have any personal knowledge of why it took so long. I don't believe that information is in the record. So I unfortunately can't answer that question. I know typically it is usually involving not having enough staff, but we have no evidence in this case why that was the case. I will say, we do have the Transfleet Enterprise case where this court held that when you have particularly factually intensive cases, it's reasonable for a fact finder to take longer. I do understand 3.5 years is an exception.
It's not just there. It's the time to get to a hearing. It's the time after the hearing. At every step of the way, mandatory obligations are not just complied with, but are not anywhere in the universe of compliance. And it may not matter here. I think the prejudice argument, there's some real challenges to that argument, but I just find it remarkable that the statutory mandatory obligations are, not complied with in the degree here.
I understand that point, Your Honor.
And it seems like it would have a direct effect on the interest, part of the award.
I understand that, Your Honor. I would like to point out again that the Translate case does explain that generally these types of time deadlines are directory. They're not mandatory. They're not jurisdictional. But that doesn't take away from the fact that it did take OSHA an extraordinarily long time to come to their decision.
Can I ask, does the agency have a view that anything you can share on, like, what are we going to do in a case? Let's assume for a minute, hypothetically, there's a case where it's an individual employee and the agency does, after 20 years, find in his favor, and the defendant can show prejudice. Like, this took way too long and it really did prejudice our ability to put on a case. Then what are we supposed to do? Like, what are our choices? Either the defendant has been, badly prejudiced and treated very unfairly, or we take away the relief from an employee who deserved it. Like this, I feel like we are headed for a very, very difficult set of questions.
I think, Your Honor, that at the point in which there is prejudice, OSHA has taken too long. But I think.
And how will we remedy that in a case where it's not OSHA itself bringing an action, but it's an individual employee who's now going to bear I guess we'll take away the award. And so because OSHA took so long, the employee is going to suffer. I mean, how are we going to, I share Judge Quattlebaum's concern that, we may not have to face these difficult questions in this case, but with delays like this, we can anticipate what will end up being an extremely difficult set of issues.
I understand that, Your Honor. I imagine that that's, part of the reason why there is that kick-out provision. I understand that employers can't use that provision, but at some point there could be, some quasi due process issue. And if that's brought up, you could look at remedies from there. OSHA doesn't have the secretary doesn't have a position on this, but I imagine, once that happens,
I hope their position is to do better.
Yes, correct. If the judges have no further questions.
Thank you.
Thank you.
Mr. Beatty?
Your Honor, that is correct, Christopher Stady. And thank you for your time today. Really appreciate it. I will be tap dancing around because I feel like it's clean up here. So just a few things. We kind of ended on the prejudice. And, again, I don't think there really truly exists a fact pattern for any prejudice on behalf of Greatwide, because nothing stopped them from completing an internal investigation back in 2012 when they received this complaint.
Why in the interest award prejudice?
Your Honor, from that perspective, I kind of defer to some of the records and some of the conference calls where even as we approached, it was Greatwide seeking the continuance. And they flat out said, will not prejudice any of the parties.
So because they sought a continuance once, they're not prejudiced by interest that's calculated over the amount of time involved here?
My understanding, respectfully, Your Honor, is that the interest starts to run from the day of the award.
From the award?
Right. It not go retroactive back to when the time was missed. It's probably unfortunate for Mr. Wang and raises the other concern.
Right. Yeah, he for sure.
Yeah. But, again, there is the case that says where a statute does not provide a remedy, it is what it is. And we really wanted to obviously have a fully staffed government. But we don't. I don't even have a fully staffed office. So, you know, you hope that you take the opportunities for people to get their records and written statements. And in this case, one of the interesting things is they kept pressing Mr. Wang to write stuff. They knew to request him to write stuff. They didn't take the opportunity to write their own notes. Keep in mind, this was a company that had its own in-house general counsel. And that in-house general counsel in 2017 stated what the reasons for Mr. Wang's termination was. And forgive me, because it had nothing to do with the drop trailer incident, which I will also be happy to address. But it was specific to breaking into the lockbox, seems to be the issue now, wiretapping a phone, which just never happened and was never found to happen. His specific quote, breaking into lockbox, stealing its contents, and secretly recording Great White's management's telephone conversations, and not due to any other reason. And, you know, that's frightening on a number of levels, because at no point by the time we got to the ALJ hearing were they still trying to maintain that he wiretapped any phone calls. I think the record was kind of clear that he put a recording device in a bullpen in the middle of an open warehouse on the outside of some cubicles. So, you know, I think the ALJ and the ARB was correct to uphold the decision. Those were just not it. And the recordings were a part, by admission, of Great White. The copying of records were a part of the reasons why he was fired. Like, we have to delve into some questions here. They kind of acknowledged, this is why we fired you. The trailer incident, if I may. And as I go through what I'm about to say, Your Honors, I just, and it's not to put anyone in the position of the ALJs and trying to redo this fact pattern, but you had a double trailer leave Maryland, go to Manhattan, go to New Jersey, and back to Maryland. Okay, that's the actual reality that's kind of logical. What the Great White version is, which no evidence supported, which is why the judge never got there, the ALJ never got there, is that the trailer, in order to have been abandoned in Manhattan, he would have had to have gone from Maryland to Manhattan to New Jersey, back to Manhattan, and then back to Maryland. I've lived in New York, you know, with the high school on Long Island, got out of there as quickly as I could. No one would ever do that. That's not a thing. What the actual conflicting testimony went into, and certainly Mr. Wang's version, is he did his first stop in Manhattan, and then he went over. Price's testimony was crystal clear. Murov, who assigned the route, Price, who reviewed the route, they were all aware that if you send a double trailer to Paramus, the trailer needs to be dropped. So the question you might have is, where was it dropped? And analysis of the transcript shows it was dropped on the parking lot outside of the tunnel. Basically, it's a Paramus Mall. You have to just go through this one little dip. But the parking lot was Nordstrom property. And that's what Mr. Hang was trying to say, in spite of all these allegations. And he was actually writing it down way back and when. I never said that I abandoned the trailer. I parked the trailer on Nordstrom property in Paramus, and then finished the route. And by the way, since he had already been to Manhattan, it stands to reason that that trailer was empty. On top of that, he mentioned that he used the glad hand lock. And on top of that, he parked a converter dolly in front of it, which means that somebody would need a special access pin to have done anything with the empty trailer. That was then parked on Nordstrom property. It's a practice that they had been doing for years. And again, Mr. Wang's unblemished employee record before his complaint, 2006 to 2012. No complaints, no nothing. It's you follow this timeline of issues of complaint, and with knowledge of the complaint, you start to see people attempt, albeit certainly not supporting a clear and convincing standard, to support a pretext for his termination. And that's where the judge struggled, because he never, I shouldn't say struggled, so the judge just never found clear and convincing evidence that he should have been terminated or would have been terminated, but for everything. And I think both the ALJ and the ARB probably somewhat cavalier in their decisions, were saying like, look, not only did I not find that these facts happened the way that Great White wants me to believe them occurred, I see nothing in these policies that would lead me to believe that the sole remedy would be termination. In fact, we even asked the questions, and sometimes you ask questions, you're going to hate the answers, but they were asked without any idea what the answers would be. Has anyone ever been fired for copying a driver's log? No. Has anyone ever been fired for this trailer incident, even if it was proven? No. So we asked the questions. There was just no reason to believe that termination was going to be the remedy that they had. Believe I've hit most of the things, so I just want to go back to the settlement agreement issue. I think the judge was clear. I don't have the equitable powers to determine what, in fact, you believe the settlement to have been. I agree that this wasn't presented to the ALJ as part of the opinion. It wasn't raised in the briefs at the end of the trial. Certainly wasn't before the ARB, and I'm very not understanding as to how it would be proper before this court. But if for some reason it is, I think the Hornbook law is crystal clear that the second you are presenting additional terms, those additional terms are a counteroffer. You have taken away the power of acceptance, period. We do not want to place courts in a position where they're sitting around going, okay, guys had 50 some odd terms out there. Here's what I'm going to cob together. That's why we have that nice, comfy, bright line rule. You do something that presents other terms, great. You have now presented a counteroffer that is available for acceptance, and you've revoked the prior ones. Just to clear the records, by the way, I did not say that the confidentiality powers should be removed, as in if we have an agreement, you should remove it. I was heightening the importance of such a term. I was noting that those types of terms are frowned upon, certainly in whistleblower action, certainly in the rubric of wage claims and stuff like that, not the business one, but that it was a material term. It was objectionable term. So yeah, adding terms, we don't just get to cavalierly throw them out. It was an added term. And then on top of that, at a time that Great White is threatening criminal action, which, by the way, like at no point did anyone look at what theft is in Maryland, but it's defined by Criminal Article 7104. And it's an intent to purposefully deprive one of their possessions. Taking a record, copying it, returning it comes nowhere near the threshold of theft or stealing like the accusation. But that's what Mr. Wang was facing. And one of those additional terms that Great White wanted to sneak in was a one-way unilateral release. It's absurd, Your Honors. But again, that was probably not proper for this court. And it wasn't presented to the ARB. I just think that there's nothing in this record to show by clear and convincing evidence that his termination would have happened, but for as retaliation for him filing this complaint, which he absolutely did. There's also no comparison to the PSP case because that gentleman never ever made a complaint. In fact, one of the funny things in that case is that they went on to say, certainly copying records would have been a protected activity. And again, it's one of the reasons why they terminated him. They absolutely terminated him for a protected activity. The burden shifted to them to show which never reached to say you're terminated for these other causes. I thank you all for your time. Unless there's any questions, I will step down.
Thank you, Mr. Stady. Ms. Bowen?
Thank you, Your Honors. Just a couple of quick responses to that. With respect to whether or not there is a case on point regarding what the authority is for dismissal or prejudice, if it's an individual defendant as opposed to the agency, that's in our brief as Roadway Express versus Dole. And if what this says is that if the delay, the prejudice, or if the delay is prejudicial and there is a consequence specified in the statute that the secretary could lose jurisdiction. So you've got to show prejudice and you've got to show a consequence. And I would argue that a consequence would be the secretary losing the jurisdiction by allowing that employee to file in district court as opposed to move it to district court because of the delay. So we've got the consequence for failing to meet those time requirements, and we have the prejudice to Great Wide, as I've already touched on. With respect to the affidavit of Mr. Stubb, again, it had been at that point 5.5 years since the termination. That is one of the cases where he did not recall in as great a detail as Mr. Scott. He wasn't one of the ones who was involved in that decision. That no other reason is clarified in the next paragraph of the affidavit that says he was not terminated. Mr. Huang was not terminated for making a safety complaint. Great Wide encourages those complaints, and the testimony was they rely on their employees to bring that to their attention. They can't be everywhere. They rely on their employees. With respect to the drop trailer incident, I completely disagree with the characterization of the testimony. Mr. Huang testified that day that he left the trailer on the Manhattan Street. I believe his testimony was that he left it there while the other trailer in Manhattan was being unloaded, but he clearly testified he left it there. That is a Great Wide company policy for a reason, and a very important reason, that Amy Price testified to during her examination. It's because of the value of the trailers, and it's the customer.
What about the fact that that's true, that you've never fired anyone else for that? As a sole sanction for that?
That was not the testimony.
What was the testimony as to other people?
I'm sorry?
What was the testimony about other persons? Certainly he wasn't the first person to drop a trailer someplace other than where you wanted him to drop it or her to drop it, correct?
So that the testimony was by Mr. Scott, there has not been any other person who has dropped the trailer unsecured, meaning off of customer property, that has not been fired as a result since they implemented the policy. And there is clear, Mr. Scott was clear, this is grounds for immediate termination. It's grounds for termination in and of itself because of the value of the trailers.
What about the evidence, the assertion that this actually was Nordstrom's property?
Wasn't the testimony. The Paramus, New Jersey store where you drop a trailer, that is Nordstrom property, so that is okay. The Manhattan store is a different store, and it was dropped on a public street in Manhattan rather than on the property. So that's the difference. It's okay to drop a trailer on Nordstrom property because Nordstrom has their own security, and it is then Nordstrom's responsibility. If you drop it off of Nordstrom property, Nordstrom has no authority. It's not on their property. Their security can't do much about it at that point. So there's a difference between the New Jersey store and the Manhattan store with respect to where it was dropped. There were no issues with him dropping it on the parking lot in New Jersey. That's not an issue because that's Nordstrom property. And just briefly, the issue with whether or not they take meal breaks or whether or not they, go get a cup of coffee, that has no bearing on dropping a trailer in that policy because, as was testified to, dropping the trailer means unhooking it and driving it away. Meal breaks or coffee stops, you are on that property with the tractor. You are not unhooking the tractor and driving it away. It's a completely different issue. You are still hooked up to that tractor. You are on the property with it. You are not leaving that tractor unhooked and unattended. So that's the difference with that. And with respect, just the employee handbook, Your Honor, those are not intended to cover every single situation.
I was not referring to Great White in particular, but rather to the emphasis that the board has always put on the distinction between could a person be fired for this and would this person have been fired for this? That's all.
Okay, and the testimony from Mr. Scott was would. And the ALJ actually asked that question. I'm not asking you, could he have been fired? Would he have been
Right,
fired?
but the ALJ thought that testimony didn't hold up in light of all of the record evidence. And so you have to persuade us that the ALJ and the board got that wrong, because they're there to make those credibility determinations to see whether that testimony was reflected in any documentation, and they thought it was not. And so, I mean, here we are.
Right, so it was reflected in the document.
Well, you had to know that it was your burden for the affirmative defense, and you, in this case, it's undisputed that the temporal nexus in this case is against you.
Oh, absolutely.
So therefore, even more so, or would have fired is more evidence you need, because it was so close to the protected activity, right?
An individual who reported Kaufman, who reported safety violations the same time as Mr. Huang, still worked there at the time of the hearing. The only difference between those two situations was there was no other action on the part of Mr. Kaufman. He had not dropped a trailer on the street. He reported a safety violation and he was still employed. So he was similarly situated. He's still employed. The difference is Mr. Huang's violation of policy.
All right. Thank you so much. Thank you, counsel all. Appreciate your being here, and wish you well and be safe. And we'll go to our next case.
Having some technical difficulties with this. Oh, wait. Chief Judge Gregory, may it please the court. Mr. Williams is serving an unconstitutional sentence because he does not have 3 prior convictions that qualify as violent felonies for purposes of the Armed Career Criminal Act. First, Virginia common law robbery, as this court held in United States versus White, does not qualify as a violent felony for purposes of ACCA. Second, Virginia's firearm offense does not require proof of firearm use against a person, against another person, or intentional use or display against another person. Starting with robbery, this case is controlled by this court's decision in United States versus White. The first step in applying the categorical approach is to identify the elements of the state offense at issue, or a federal offense if the federal offense is at issue. In response to a certified question from this court, the Virginia Supreme Court identified the elements of Virginia common law robbery, as it has done for the last several centuries. It is defined as the taking with the intent to steal the personal property of another from his persons or presence against his will by violence or intimidation. The Virginia Supreme Court held that these elements could be satisfied by non-violent means. The court is bound by the Virginia Supreme Court's interpretation of state law. As the court
Counsel, is the only way that common law murder in Virginia can be, common law robbery, I'm sorry, in Virginia can be committed in a way that's not a crime of violence is through the threat of sodomy?
I believe that's correct, yes.
Okay.
But as the court said in White, this court is bound by the Virginia Supreme Court's interpretation of that state law. And the government's Hail Mary response to this court's opinion in United States versus White is to point to the punishment statute, Virginia Code 18.2-58. The problem is that the Virginia Supreme Court has already said what the elements of the offense are. And those elements do not include the words in 18.2-58. And so the government starts in the wrong place, as we've said. You cannot look to the punishment statute to determine the elements of the offense.
Counsel, is your position that you can never look at a penalty provision to establish the elements of an offense, or just that in this case you can't?
Of course, the court can. I believe the court in Mathis said that following Apprendi and Elaine, of course, there is a constitutional Sixth Amendment definition of elements, and that can help courts in identifying the elements of the offense. But in this case, well before Elaine and Apprendi, but even now, the elements of Virginia robbery are not defined by reference to the words in 18.2-58. That's for a number of reasons. One, the government mischaracterizes the punishment statute as a mandatory minimum statute, when the punishment under that provision can be entirely suspended by the trial court. But secondly, they start the divisibility question without looking first to the elements as defined by the Virginia Supreme Court. And so they start the divisibility inquiry by not looking at the elements that this court said in White it was bound by principles of federalism. As we all know, the Supreme Court of Virginia is the ultimate expositor of Virginia law. And so there is a step here that the government cannot get around, and that is, what are the elements of this offense under Virginia common law robbery? And those are defined by Virginia state law and by the highest court of this Commonwealth to include commission by nonviolent means. And that ends the issue, as we've said. There is no way to get around that fact. And the government cannot point to the punishment statute when the highest court has said you do not look to that punishment statute to define the elements of Virginia common law. I will be happy to move on to our to the second set of convictions here, unless the court has any other questions about Virginia common law robbery. Mr. Williams also has 3 convictions for violating Virginia's firearm offense, 18.2-53.1. That is a statutory offense, not an offense defined by common law. If I can say one more word about Virginia common law robbery, the way it's charged is simply, and it's charged now and charged at the time that Mr. Williams was prosecuted, is simply by using the word robbery, that Mr. Williams did rob a victim. And that word robbery incorporates those elements of the common law that the Virginia Supreme Court identified. So there is no accusation of divisible words. The charging of robbery is simply to say that the defendant robbed a victim. There is no alternative phrasing or various ways that individuals can be charged with that offense. But moving on to the firearm offense, this is an extremely broad offense that is very different from some other offenses that require the use of a firearm against a victim. The words of this offense, and again, this is where we start the categorical approach, is simply that it prohibits the use of a firearm during a predicate offense, or the display in a threatening manner during a predicate offense. None of those words require, well, first starting with use. I would suggest that these are alternative means of, this is not a divisible offense in that if you look at the way that Virginia charges it, they do not require the charging document to say either use or display against a person. And in fact, we've, not that we believe that this is governed by the modified categorical approach, but we've put in Mr. Williams' charging documents, and several of his charges include both use and display against a victim, or a display in a threatening manner, not against a victim. But first, with respect to the word use, Virginia courts define that the same way that the federal courts define it in the context of 924C. That is extremely broadly. It simply means to employ as to any purpose. And
Counsel, if I could, ask you a question on this part of the issue. I asked you earlier if the only way committing common law robbery in Virginia that is not a crime of violence is through the threat of sodomy, and you said yes, which is what I understood the case to be too. As I understand it, the Virginia Davis case requires to be convicted of this offense that you prove both the primary aspect, the use of a firearm, and then the elements of the predicate crimes, whichever one is being talked about.
That's correct. And absolutely, the elements of this offense are charged in connection with the predicate. And that's my friend's major argument, that even if individually these elements don't satisfy the force clause, that when you put them together, that they necessarily satisfy the force clause. And the problem is that there is nothing in this statute that requires the use of a firearm to be used to commit the robbery. There is nothing that requires for.
But if, I'm sorry, if I could just finish the point, but if robbery is a crime of violence, just hear me out. Let me finish my question, please. If but for the threat of sodomy, robbery would be a crime of violence. Stokeling would tell us that, our Dinkins case would tell us that. And we have this situation in Virginia that's like Virginia law has a way of committing common law robbery that takes that away. Why doesn't the predicate use of the requirement of the first part of the statute exclude the only way you could otherwise commit common law robbery and it not be a crime of violence?
Two reasons. First, the use of a firearm doesn't have to be used in the direction of a person. And secondly, there's nothing in the statute that requires the use of the firearm to be related to the predicate offense. I may have some differences on that, but taking that as true, it's common law robbery, we know, absent this threat of sodomy, is a crime of violence. And whether or not the first part of the statute is enough by itself to be a threat of violence, it excludes the one thing, the one circumstance in the way you can commit common law robbery that wouldn't be a crime of violence. And that's where we part ways, and I disagree.
Well, doesn't the first part of it preclude threatening someone with sodomy to committing robbery by threatening someone with sodomy?
Not at all. And
you don't think the first part of the statute precludes that?
Yeah, and I can give you a concrete example.
Okay.
Individual trespasses on a victim's property and uses a firearm against a door that's locked, gets in the door, and then commits the taking through a threat of accusing the victim of engaging in an unnatural act. That there is nothing that precludes those set of circumstances under this statute, because the use of the firearm doesn't have to have any relation to the predicate. And so
Doesn't it have to be while they're committing the robbery, and the robbery has to be taking property from the person? So I don't see how using it to break into a door and then later threatening sodomy is going to work.
Well, this again comes down to Virginia law, and Virginia law defines the temporal space of Virginia robbery, which occurs from the moment a person trespasses on a victim's property to the time they leave. And so, for example, if an individual commits a robbery and leaves with the property and is confronted by a policeman and points the firearm at himself and says, back away or I will shoot myself. That also would satisfy the terms of these.
Well, I gotta
this
say,
statute.
on that one, I will say that just as kind of a practical common sense matter, I am struggling to think of a case that, is more than just really purely hypothetical, where someone is committing robbery by way of a threat of a charge of sodomy and using or displaying a gun, but it's not a crime of violence. And one of the reasons is because I would imagine that if you are in the process of taking property by intimidation directed at the person and you are displaying a gun, whether you are threatening to shoot yourself or scratching your nose or whatever, that seems like it would carry a pretty strong implicit threat of violence. You're displaying a gun while you are in the process of intimidating someone. How is that not threatening?
Well, it may be threatening to a reasonable person, but that's not sufficient to satisfy the force clause. The threat has to be intentional and directed at another person. But secondly, the question is, I think the predicate of your question is that the firearm must be displayed during the taking. And that's not what Virginia law requires. This is not.
Well, it's got to be displayed in a threatening manner. And so to use the gun to gain entry isn't, maybe your argument is isn't threatening, isn't using it's to gain entry, and maybe it is in the connection with the temporal aspect of the robbery, but that's not in a threatening manner.
To be clear, the statute's in the disjunctive, meaning you can prove either use or threatened display. And so an individual can meet the elements of the offense simply by using the firearm at some point that is not related to the taking, such as breaking into a locked door. All right. So if someone and again, we're not in the realm of deciding how this case will most likely occur. That's the residual clause. That's when the judges get the opportunity to decide what is most likely to happen. We're just looking at the elements. And again, the elements themselves require no relation between the use of the firearm and the actual predicate offense. And so I gave the example from Smith versus United States, which is a case about 924C. And in that case, the individual was exchanging a gun in return for drugs. And the question under 924C, which requires use during and in relation to a predicate offense, is that a use? And the court said, well, it is a use, you're bartering, and it's in relation to the predicate offense, the trading of the drugs. And in dissent, Justice Scalia says, well, if you're going to define use that way, then what about just using a gun to scratch your head? And what the majority said is, yes, that would be a use as well. But 924C requires a connection between that use and the predicate. And that's just absent in this Virginia statute.
Can I ask you a question? Are we in, so your argument must be, and the language is perfectly clear on this point, right? The predicate of your argument, I assume, is that we're in one of those cases where state law is so clear that you could commit this crime in a nonviolent way that we don't have to ask. We're not in that other bucket of cases where we ask, look, is there any reasonable chance that anyone is ever going to be prosecuted under this theory?
That's right. And so the way that we look at this in applying the Duenas-Alvarez argument that the government has made is, first, does the text overlap with the force clause? That, for example, in Duenas-Alvarez, the defendant said, yes, this is a theft offense, and it could be considered under the immigration laws an aggravated felony. If I can finish, I'm about to go over my time. But the California law has an idiosyncratic way of looking at attempted theft that falls outside of the generic offense. And so you get into that realm, that second bucket of cases, when there's already overlap by the text with the definition of a crime of violence, or in that case, an aggravated felony. And here we don't even get there because there is no overlap with this offense and the force clause. It doesn't require the use of force against a person. It doesn't require use of force or the presentation of a firearm against another person. We cited Breeden, for example, and Breeden is a case where the defendant was convicted. I'll just finish on this. that the defendant was convicted of this statute, 18.2-53.1, with the use of the firearm directed at himself. And that establishes that under Virginia law, there is no overlap with the force clause because it doesn't require the display of the firearm against another person.
It's good.
May it please the court. I'd like to start with points about Virginia robbery. And the first point would be when the Virginia Supreme Court decided this certified question from this court, the certified question was the scope of common law Virginia robbery. Everyone agrees in this case that the Virginia General Assembly has changed the penalty provisions over the years in multiple ways. Most recently, the penalty provision scales the crime of robbery from all the way from a class 6 felony all the way up to a class 2 felony. Necessarily, that is a series of distinct crimes under Mathis. The Virginia Supreme Court also agreed that the General Assembly can change what the common law has provided. And so we know that the Virginia General Assembly has multiple times changed the penalty statute. We know that most recently the penalty statute does create distinct crimes. And then as to these crimes in particular, which were committed after the amendment in 1975, the defendant has, and this is, I think, important, one argument and one argument only about how the threat to accuse someone of robbery fits within the statute that authorizes the punishment for robbery. And that is the only statute that authorizes punishment. We know from 18.2-16 that you have to have a statute that authorizes punishment to impose punishment for a crime in Virginia. And the one provision in Virginia law at the time of this defendant's crimes that he could fit sodomy threat theory is the language about a defendant who puts a person in fear of serious bodily harm. And there's just no way to fit a threat to accuse somebody of sodomy into putting a person in fear of serious bodily harm. This threat to accuse somebody of sodomy is concerned with a reputational harm. It is not a threat to put somebody in fear of serious bodily injury. As I understand the defendant's position in his reply brief, the sole way that he thinks you can fit a threat to accuse somebody of sodomy within that phrase, putting a person in fear of serious bodily harm, is, well, they said that a threat to accuse somebody of sodomy is constructive violence. And therefore, if it's constructive violence, somehow that's got to be putting a person in fear of serious bodily harm. That's not right.
Counsel, can I want to make sure I understand where you are in your argument. What if, I actually think this is sort of an interesting question because those old cases do seem to treat it as sort of the equivalent of a fear of bodily harm. But what if I just assume, absolutely, the defendant in this case was sentenced under this penalty provision. The penalty provision only applies to what we think of as violent crimes. And so fine, this defendant was sentenced for a violent robbery. I just don't understand where that gets you because I don't see any evidence that that at the time, or I guess even now, but certainly at the time, pre-Apprendi, that the state was treating these as elements of a separate offense that had to be proven before a jury or admitted to in allocution. How do we know a judge didn't just make a finding? Oh yeah, it seems violent.
Right. So I think the answer to that question is that as a matter of law, it was impossible to have punishment imposed for a threat to accuse someone of sodomy after the 1975 legislation. And that's true for a variety of reasons.
No, but what if, doesn't it have to be the case for this to work? I thought it would have to be the case that these penalty provisions were found, that the violent part of the penalty was found by a jury or admitted by the defendant. Is that not right? It would be okay if the judge just found as a sentencing factor, this was violent?
No, it's not a question about the fact finder. It is a question about, can lawfully punishment be imposed for the sodomy threat theory? It cannot as a matter of law. and that is very clear. I don't think the defendant has a even colorable argument that if the 1975 statute does not cover a threat to accuse someone of sodomy, that you could punish someone. That is clear for multiple reasons. The first is 18.2-16, and this is a point the district court made, would preclude punishment for when the statute doesn't cover it. The only statute out here that could trigger punishment for robbery is 18.2-58. There isn't another one. The conduct here would not fall within 18.2-58. So there, under 18.2-16, there is no punishment available for that crime. Now, that's strange, but we know from the Virginia Supreme Court's opinion in Wackwitz that Virginia recognizes that in some sense you can have criminal liability out there and no available punishment. Now, as a matter of federal constitutional law and indeed Virginia law, it is also true as a matter of due process that you cannot punish somebody when you have failed to provide any kind of notice about what the punishment would be. And this court's case, United States versus Under Seal, citing a series of Supreme Court cases, makes that clear. You can also run this through Apprendi law. If, as a matter of the statute at issue, there is no punishment available, and then you make you're going to impose, say, up to life imprisonment, which would be the available punishment under 18.2-58 at the time, you'd have to meet the requirements of the statute that authorizes that punishment. And here the requirements would not be met. There's just, you cannot, a defendant who came into court and said, you know what, the government agrees that a threat to accuse someone of sodomy does not constitute putting a person in fear of serious bodily harm. They agree with that. And yet they're going to ask for a sentence with the.
I feel like I'm just having a conceptual problem here, and I will let it go in a minute. This may just be something I don't understand, but I feel like what you're trying to prove. So we must be able to figure out what this guy really did. We must know that the facts of this case don't involve a sodomy threat, or he couldn't have been punished. But I don't understand how that's the question under the categorical approach. I thought we had to figure out, like we always do, we look at this penalty provision. Are these just different means of committing common law robbery, or are they actually elements of a standalone offense? And there is no evidence here that they are elements of an offense because they don't get charged. We don't know, at least there are no Shepard documents in this case indicating that they were charged to a jury. It just looks, when you look at it, like these are probably sentencing factors found by a judge. And so if we're doing the elements analysis under Mathis, I just don't see how these can be, I don't see how any of this helps you. I feel like you are making a good, practical, kind of common sense case that we can probably figure out what really happened in this case, but that's not the question.
Well, I would disagree with that last point, which I think is critical, which is it is not a factual question. It is not a matter of going and looking at Shepard documents. It is a matter of looking at the relevant state law provisions and saying, as a matter of law, you cannot be punished under that 1975 statute.
Unless a judge finds that you did something violent.
No, there's no way you can be punished under that statute for the sodomy threat theory. Put differently, the legislature eliminated a punishment scheme for that theory in robbery. It doesn't exist as a available method of proving.
So then that's just White is wrong.
I'm sorry?
Then the Supreme Court of Virginia got that wrong in White, and we got it wrong in White.
And that's why the Virginia Supreme Court's Wackwitz opinion is really important. They say that this is a thing in Virginia where you can have a theory of criminal liability with no punishment. That's what happened with suicide.
But that does mean that White was wrong, because the Virginia Supreme Court said in White, oh yeah, you can totally commit this crime with a sodomy threat. Well, and to your credit, your brief says you think White is wrong, but I don't know. I don't see how that helps us.
But Your Honor, I think you're forgetting that, look, when the cases that the Virginia Supreme Court identified as endorsing the sodomy threat theory Houston from 1890, Fleming, Maxwell, and the third is what, Falden. Those are from the 1890 and then the 1930s. At that time, there was a penalty provision in Virginia that would reach a sodomy threat theory. It had a 18.2-58 at that
But the
time.
question why it wasn't back in the 1800s, what were the elements of common law robbery? It was today, what are the elements of common law robbery?
I disagree with that. The
Okay.
certified question was, what does Virginia common law robbery cover? They answered that question by going back to when they adopted English law, they thought common law robbery covered. And then in the intervening years, the Virginia General Assembly changed what is the authorized punishment scheme multiple times. That has consequences. The defendant's view is basically like, yeah, all those future legislative acts are basically a nullity. They didn't do anything to change Virginia robbery. That's just crazy. I mean, the legislation has very different wording, it has very different penalty schemes. A defendant could not be subject to punishment under a expired penalty scheme. And so it just cannot be, as a matter of law, not as a matter of looking at facts, as a matter of law, that this punishment scheme could work. I mean, I sense that the court may not be agreeing with the government, so I don't want to belabor this point when there's also this available theory under 18.2-53.1. But I do think it's important because, number one, it's right. As a matter of law, you could not be punished after the 1975 legislation for threatening to accuse somebody of sodomy. That just is not a matter of putting a person in fear of serious bodily harm. That just doesn't fit that language. And let me briefly, before I go back to the firearm statute, say that the defendant's theory about how you fit within that language is that it constitutes constructive violence. If you look at what the Virginia Supreme Court cited for this concept of constructive violence, it cited William Oldnall Russell's treatise, an old common law treatise, and it also has cited Lefebvre, and both of those treatises say what constructive violence means is just that's a different phrase for intimidation, which everyone understands. Robbery is committed through a use of force or intimidation. But it's putting the rabbit in the hat to say that just using the phrase constructive violence then gets you around the very specific way that the 1975 version of 18.2-58 defines what is intimidation. And it gives you two things. It has, or three rather. Thing number one is assault. The defendant doesn't claim that assault could reach a threat to accuse someone of sodomy. And that's right. It couldn't if you go and look at how Virginia has defined an assault. And remember, this is assault in the context of seeking to overcome somebody's will. Then there's also using a firearm or brandishing it or displaying a firearm. That is going to obviously exclude the sodomy threat theory. And then you're left with putting a person in fear of serious bodily harm. And threatening to accuse somebody of sodomy simply is not putting a person in fear of serious bodily harm. I don't even understand how it could be that. So what the defendant is left with is, at the time of his convictions, there was this theory of liability for which no punishment was authorized, and that's why his offenses do not count. And I mean, you can look at that as a matter of Mathis. You could look at it also as a matter of this, Duenas Alvarez point about what is a realistic possibility. And if, as a matter of law, no punishment could be imposed for a theory, that's compelling evidence that there is no reasonable possibility that that would be the crime. Against a backdrop, too, where I would say that no one can point to any American case in the history of the United States where somebody actually was found guilty of robbery using the sodomy threat theory. It's an anachronism from the 1700s that has become irrelevant in American society.
Right, that's why the White decision was so surprising, but I just don't understand how on common law robbery, we are in the bucket of cases where we say, is there any reasonable probability this will be charged? Because we asked the Supreme Court, what are the elements? And they told us, like, I don't think at this point we can say, yeah, that seems sort of far-fetched.
Right, but Your Honor, the Virginia Supreme Court answered the question about how they define Virginia common law robbery. And they said that, by the way, under our law, and they're absolutely correct about this, that the General Assembly can modify what the common law standard is. And everyone agrees that the General Assembly has repeatedly changed the punishment scheme. And so, I mean, what I find kind of hard to wrap my head around here is that if we are not applying the categorical approach and we had a defendant who was convicted under that 1975 statute using the sodomy threat theory, I have no doubt, and it would be absolutely correct, that a court would say, there's no punishment authorized that violates 18.2-16. It violates due process principles. It violates Apprendi principles, because if you are going to use a theory of punishment that's covered by the statute, it would have to fall within it. And so, but let me go on to the firearm statute, because I think the firearm statute is kind of the final nail in the coffin here for this defendant, which is, as Judge Quattlebaum was pointing out, you have to prove, and the defendant agrees with this, the predicate robbery offense for the Virginia firearm statute. So all those elements of Virginia robbery have to be satisfied. The only way that Virginia robbery doesn't count is via the sodomy threat theory. So to get the firearm offense within the elements clause, the one and only thing that the firearm elements have to do is take you outside of this sodomy threat theory. It's functionally very similar to what I'm saying about the penalty statute for Virginia robbery. It just happens to be now we are clearly talking about a different crime. Does it narrow and exclude the sodomy threat theory? And the answer to that is yes. Number one, you're talking about a crime where the defendant is going in, intending to steal something, seeking to overcome the defendant's will, has a firearm, uses or displays it. When all of those things are added up together, you have met the elements clause, even if the defendant happens to have this, I'm accusing you of sodomy thrown in there. Indeed, realistically, that would be such a bizarre scenario. I think any real person would be like terrified because the robber would seem unhinged. I mean, you're using a gun, say, to scratch your head. I mean, that's madness. I mean, who knows what somebody like that would do? And one fine-grained point, I think I heard my friends say, yeah, but maybe the defendant wouldn't have specifically intended all that. That's a new argument, not in the briefs, and I would say basically it's answered by this court's opinion in McNeil, which dealt with federal bank robbery. And in McNeil, federal bank robbery has this like objective standard. How would the victim understand the circumstances in a threat scenario? And the argument was, well, because you use that standard, it must be that that this is not an intentional use of force. You got a problem under Borden because the intimidation could occur like recklessly. And McNeil back in 2016, when before Borden, this court agreed with the recklessness offenses are out, said no, that's not right, because the basic idea is that you have to know that you are intimidating people, and that is definitely going to be the case in all of these robbery crimes, because that's the dividing line between larceny and robbery, and that's enough to get you to satisfying any kind of recklessness problem. So which is a long-winded way of saying it does meet the elements clause to go and threaten to accuse somebody of sodomy as a way to, you're intending to get stuff from them against their will and scratch your head with a gun. That's intimidating.
Can I ask you a question? I'm trying to figure out, and I asked your colleague this too, sort of which bucket we're in here, whether this is, are we in the bucket where you would ask whether, like, come on, is there any reasonable chance anyone is going to be charged under these hypothetical scenarios? Or are we under the bucket where, look, the language says what it says, and I can imagine a circumstance where someone uses a gun to break and enter, then puts the gun away, nobody ever sees it, and decides, I'm not going to use the gun, I'm going to use the sodomy threat to commit my robbery. If I can imagine that consistent with the language, I mean, is this just one of those cases where the categorical approach takes you somewhere that maybe doesn't exactly overlap with common sense? Or is this the kind of case where the language is sufficiently unclear, there's something sufficiently unclear here that we can ask, is this a reasonably foreseeable kind of a charge?
It's the last scenario that you were referring to, where the language does not definitively answer this. The cases in Virginia about this statute definitely do not endorse a theory of use as far-reaching as the defendant does. And the language is used or attempted to use or display the firearm in a threatening manner. I think implicitly he's conceding that the display of the firearm in a threatening manner is a problem for him. That's going to satisfy the elements clause. And so it's just that somehow the used or attempted to use, which is accompanied by this displayed in a threatening manner, would reach scenarios that would fail to satisfy the elements clause. I don't think there's support in the Virginia cases to say that. And so
what about his example? What about you use the gun to break and enter, to trespass onto the property, put the gun away, now you commit the robbery by threatening to accuse someone of sodomy?
I don't see any case that says that that's right, that you could rely on such a theory. But remember,
I'm sorry, what's wrong? What you would say, I really want to make sure I understand this. You're saying you think that goes outside use as that word is used in this statute?
I do, but also can't lose sight of the really important point here that makes this an easier case, that we are now talking about robbery having to be proven as the predicate here. And so it has to fit within the elements of robbery. The elements of robbery are going to require that you are directing your intimidation at the person.
That's the part where you're threatening to accuse them of sodomy.
Right, but you also have to have a gun and use it during the crime.
So are you suggesting that the using it to trespass, then putting it away and not using it again?
Right.
That's not rob.
I
using
think
the
so in
gun.
the context of a crime where you have to, during the overcoming of the will, basically, I think is the way this is going to shake out, have to have intimidated the person, and so you have to have the gun. I mean, a different way to come at this is more simply that I don't think there's a definitive answer in this statutory language. The realistic possibility language still has, force in this context Taylor emphasized kind of the federalism comedy angle on it, and that would be directly applicable here about where you're saying, well, there could be this sodomy threat theory, and somehow the person has to have a gun that they use, and it is not a use that contributes to the overcoming the will, even though it has to occur during the robbery. That's just far-fetched, and the whole point of having this exception when you're dealing with a state crime for realistic possibility is directly at play there. I see that my time is up. I don't want to wear out my welcome.
Thank you, Mr. Kamens.
Again, where I started with respect to robbery, the question for the court is, what are the elements of the offense? And the Virginia Supreme Court has told us what those elements are and has said that the punishment statute does not define those elements. That's in the on page 484 of the Virginia Supreme Court's opinion. The Virginia Supreme Court also said that a threat of intimidation that includes a threat of accusing the victim of engaging in sodomy inspires as great a degree of fear as the threat of personal violence. And so it is clear under the statute that it is encompassed by this punishment statute 18.258, which was amended in 1975 to include not only commission of the offense by violence, but also putting the victim in fear. Last point, the government says it's impossible to commit this offense and be punished by 18.2-58 with the sodomy threat theory. And that assumes that 18.2-58 provides mandatory penalties. And my friend provided zero response to the argument that these punishments are not mandatory and may be suspended by the trial judge. And that means that they fall outside of the argument of Elaine and Apprendi that they constitute elements of the offense. The elements of common law robbery, which is the offense that Mr. Williams was convicted of, includes nonviolent means as a categorical matter. And that is the offense of a conviction, and it doesn't satisfy 924E's definition of a violent felony. With respect to 53.1, the question for this court is whether that statute requires the use of the firearm or the display in a threatening manner to be used to accomplish the violence and intimidation of the predicate robbery offense. That's what my friend has argued, that it necessarily requires the use of the firearm or the display in a threatening manner to occur at the time or to accomplish the elements of robbery for violence and intimidation. But that is nowhere in Virginia's statutory text. All it requires is that the firearm be used, which is defined by Rose versus Commonwealth as to employ. It does not require that use to occur to accomplish the violence or intimidation for the predicate offense. And we've cited Rowland versus Commonwealth, a Virginia Supreme Court case. Now, the predicate in that case is burglary, but what the court, in vacating the defendant's conviction under this statute, 18.2-53.1, said there's no evidence that during the burglary, which was the engaging in coming into the restaurant, there's no evidence that the defendant used the firearm or threatened or displayed the firearm in a threatening manner when entering the restaurant. And they said that was it. That's the burglary. It wasn't done during that offense. Therefore, they vacated the conviction. Now, the government also does not respond to our cite of Briley versus Commonwealth on page 18 of our reply brief, which says, black letter Virginia law, that in a robbery prosecution where the violence against the victim and the trespass to his property combine in a continuing unbroken sequence of events, the robbery itself continues as well for the same period of time. It is a continuing offense. It is not simply defined by the time period that an individual uses violence or intimidation to accomplish the taking. It starts at the beginning of the trespass and ends when the property is taken away from the victim's property. Therefore, the government cannot establish that the statutory text in this case requires the use of a firearm or the display in a threatening manner against a victim to accomplish the robbery. The government briefly said that we had a new response about Borden and implicit threats. That is, that when an individual uses a firearm to threaten themselves, and the government responded in its reply brief that that would implicitly result in a threat of harm to the victim. Our reply brief in responding to the government's argument, so it was not new, was Borden. And that is that to be a violent felony, the government has to establish that these elements require intentional use of force, not against another person, not simply the implicit reasonable fear that might happen in a victim when an individual threatens self-harm, but intentional use or directed violence against a victim. And this statute allows for it to be satisfied through threats of self-harm. And we've identified a Virginia case, Breeden, which establishes that point, and the statutory text makes that equally clear. This is not a statute like the court looked at in Burns-Johnson, which is another firearm it's an armed robbery statute.
Counsel, on the intentional issue that you say Borden requires, Borden it left open the reckless disregard conduct, and we've since determined that reckless disregard can constitutes satisfies the board, is not precluded and constitutes a crime of violence.
The language was extreme recklessness.
Yeah, maybe right. Yeah, thank you. Does that does putting a gun to your head constitute extreme recklessness that falls with under our decision there?
I think the question is, do these statutory elements require a showing of extreme recklessness directed at a victim? This statute doesn't require anything directed at a victim. It can be towards property.
Yeah, but your example of threat of self-harm is what I'm getting at. Does the threat of self-harm that you say is an exception to how this can be used as a threat against another? I think it's our Manley case. I can't remember. Does it fall under the extreme recklessness of Manley?
If I can respond, I'm over my time. The answer is no, because these elements don't require that mens rea of extreme recklessness, even if the court might consider, well, if you engage in self-harm, that could potentially result in extreme recklessness. The question is, do the elements of the offense?
Yeah.
And the elements don't. They don't even require anything directed at a person. For those reasons, we'd ask the court to vacate the judgment below and remand for the direction for the district court to grant the 2255.
Thank you, Mr. Cameron, Mr. Cook, for your arguments. Appreciate your being here. Wish you well. Stay safe. Thank you. We'll proceed to the next case. Stetson.
Good morning, Your Honors, and may it please the court. My name is Kate Stetson. I am here as a sponsor of the Appellate Litigation Clinic at the University of Virginia School of Law, and it's my pleasure to introduce to you Sierra Barone and Walker Fortenberry, who will be arguing the case today. Ms. Barone will argue the opening. Ms. Fortenberry will argue rebuttal. Thank you.
Thank you. Ms. Barone.
Thank you, Your Honors, and may it please the court. My name is Sierra Barone, and on behalf of Mr. Stewart, we ask you to grant the motion for authorization to file a successive habeas petition. This court-appointed counsel to address the question of whether recovered memories can constitute newly discovered evidence under Section 2244B2. The answer is yes. The statute imposes no limitations on the type of evidence that can be considered newly recovered. Instead, the thrust of the statute comes from subsections B2B1 and B2B2 that place stringent requirements on the factual predicate. Regardless of the type of evidence being presented, a petitioner will have to satisfy those strict requirements in order to be successful in their habeas petition. But as this court explained in In re Stevens, at this stage, the petitioner need not satisfy the court that he can meet those strict requirements. Instead, all that is required is a prima facie showing that he can do so. In Hubbard, this court said that the prima facie showing was a relatively low bar. And in Williams, this court said that all that is required is a sufficient showing of possible merit to warrant a fuller exploration by the district court. Mr. Stewart makes that showing of possible merit. Mr. Stewart's motion is also not barred by any procedural hurdles. This court, sitting en banc in Long v. Hooks, recognized the Supreme Court's holding in McQuiggins, which allows a showing of actual innocence to serve as a gateway through otherwise procedurally defaulted or out-of-time claims. This actual innocence standard is the same exact actual innocence standard presented in subsection B2B2 of this statute. It's also the same language that we see in section 2254E, which the state points to as an additional hurdle. And so if Mr. Stewart is able to satisfy just the regular requirements of the statute, then under McQuiggan, he does not have to worry about those procedural bars.
Does the actual innocence have to result from a constitutional error?
That's correct. For purposes of McQuiggan, I don't know that the actual innocence has to result from the error, but as far as the procedural hurdles. But as far as this specific statute, yes, that constitutional error is one of those requirements.
And so you agree that has to be shown for us to grant the certificate?
Yes, absolutely.
Okay.
And so turning to that first requirement, which is showing a constitutional violation, there are two potential constitutional violations here that can serve as the basis for Mr. Stewart's claim. The first is actually the question the Supreme Court left open in McQuiggan, which is whether actual innocence is a freestanding constitutional claim. The second is that the second constitutional claim is a due process violation because Mr. Stewart was not competent to stand trial in light of his dissociative amnesia.
Counsel, I don't want to throw you off early, but I do have a concern that the actual petition in front of us, which is really quite well done, even though it was pro se. I mean, it does specify very clearly, like I'm bringing 3 constitutional claims and here they are. It's a Brady claim, an NAPU claim, and one that's both a violation of Brady and NAPU. And here's my newly discovered evidence. And it's the evidence that was suppressed about the pathologist report and then the investigative report. And although we do absolutely read pro se petitions very generously, it would seem it would be sort of a big lift to take a petition that says, I am identifying for you clearly my 3 constitutional claims and the newly discovered evidence that is the predicate for those claims, and then read that petition as also saying somewhere, also I have a 4th claim and it said I was incompetent to stand trial.
Well, of course, as you said, this was a pro se filing. And so I do plan on talking about those 3 otherwise enumerated.
No, I was not asking you to talk about them, but rather to talk about how we find that 4th claim in this petition.
Well, because even though Mr. Stewart didn't explicitly enumerate it, he spent a great amount of his pro se petition talking about those recovered memories. And so I don't think it's a situation where this court is sort of pulling out of thin air.
Well, he does raise the recovered memories, but he does not say that they are the predicate for a constitutional claim that he was tried while incompetent.
That's correct, Your Honor. But since he does mention it, I think that this court in construing the pro se petition saw that, and that is what this court did appoint counsel on. And of course, that is
that's not law of the case or anything. Or are you suggesting that that is now law of the case, that we have already sort of definitively ruled that there is a 4th claim in this petition?
It was my understanding that through appointing counsel, this court was construing the pro se petition as having that 4th claim. But even if that were not the case, I think this court should absolutely do so, partly because it would be a claim of actual innocence. And of course, those procedural bars, which we see under McQuiggan, we don't want those type of procedural bars to hinder a situation where there is actual innocence being presented. And because Mr. Stewart did spend a great amount of time talking about the implications and the significance of those recovered memories. And so I do think that it should be considered a 4th claim here. And so the basis for that claim, the constitutional violation, would be that due process violation that stemmed from his incompetence at trial. Now, the DC Circuit in Wilson addressed a situation where there was amnesia being presented and considered whether it would result in a due process violation. And the answer is, well, of course, it's not always going to result in a due process violation. We have to look at the overall fairness of the trial. That is what the DC Circuit read from the Supreme Court's Dusky competence test, whether at heart the defendant was able to have a fair trial. And the Wilson court laid out several factors that could be considered in determining whether the amnesia affected the fairness of the trial. One of those things was the extent to which the evidence could be extrinsically reconstructed. And in Wilson, the district court at least had indicated that because of all of the other evidence that was available, it was possible to extrinsically reconstruct what had happened. And so in Wilson, Wilson was committed an assault, had also committed some sort of robbery where he was stealing money, and then a car chase ensued with police. That car chase resulted in a car crash, which is where Wilson had lost his memories. That was the source of his amnesia. But the evidence, among other things, included being found, of course, in that identified stolen vehicle with money, a firearm, and a ski mask and hat that had matched other types of identification. And so there was enough evidence that could extrinsically recreate what had happened. Here, we don't see that at all because Mr. Stewart was the only eyewitness there. And even though there was also state witnesses testifying against Mr. Stewart, that testimony was directly based off of the things that Mr. Stewart had said to them on that day. And so all of it stems from, or almost all of it stems from and relies upon Mr. Stewart's memories, which we now know to be tainted by mental illness.
Can I ask you a question? I did I read your brief on the dissociative amnesia and the evaluation you had done for your client. And I think I understand sort of the theory on why your client might forget what happened. But is there something in there that explains why he didn't just say, I don't recall? He said, no, I have a very detailed story about what happened and it was something different. And I can sort of intuit how, if you have amnesia, you might fill in the blanks yourself, but I didn't see anything explaining it. This isn't just a case where at trial he said, I don't remember. At trial, he gave a very, very detailed account that is inconsistent with the memory he now has. So how does that happen? How do we deal with that?
So the DSM has talked about, what amnesia can look like. And so based off of how information is stored into the brain, it can make the memories, of course, incomplete, or perhaps there would be a gap, but it can also manifest in other ways. And so there's a citation, I believe, in appointed counsel's opening brief. The site, I don't have the page number, but the name of the academic, I believe, is Nikolai Axmacher from 2010. And he talks about how.
But I mean, this isn't in the. So I take it what you would say is this might not exactly be in the record, but this is enough for a prima facie case. Like this is
that's correct,
sufficiently credible what happened here. Let the district court build a record.
That's absolutely right. I would say to what you had just pointed out about letting the district court handle it, this is one of those things where there's a lot of information missing in this case, but that information is absolutely accessible. And so there was a preliminary psychiatric evaluation here of Mr. Stewart specifically, but it was said that further evaluation would be necessary. And so at this prima facie stage where we just have to show a possibility, Mr. Stewart doesn't have to ultimately prove it yet. We believe that there's enough information here to satisfy that.
Oh, I'm sorry, go ahead.
Does it matter, the expert or consultant that basically said, I can't rule it in, can't rule it out. Is there a problem that, Mr. Stewart identified this newly discovered memory in 2014 and asserted it twice in state court without developing any evidence? And now if you're successful, you will ask to develop evidence in federal court that was discovered earlier, alleged earlier in state court and not developed. Does that present a problem for you?
I don't think so, Your Honor. So looking at Shin talks about whether the defendant was at fault. So it talks about, I think, negligent failure is the phrase used there. And so we see in the record that Mr. Stewart requested from the state court this type of evidentiary hearing and discovery in order to prove his claims, and the state court said no. And so we wouldn't see any type of bar from him not from a failure point of view. But then even within that, I think what you're talking about, Your Honor, goes back to 2254E, which the state points to in their brief. And again, we see there that there is an exception for if the petitioner is able to establish actual innocence. So I think even if this court were to find that it was Mr. Stewart's fault or that there was a negligent failure to gain evidence for these claims, that could be excused by his actual innocence. Now, I do think that he,
Counsel, can I ask you, how we should conceptualize the inquiry we have to do under whatever it is, subsection 2I's, that but for the constitutional error, so had he not been tried before he had this recovered memory, you can show by clear and convincing evidence that no reasonable fact finder would have found the applicant guilty. So as I am conceptualizing this, but tell me if I'm wrong. So I say to myself, all right, let's assume he's tried after he has the recovered memory. So now he's not going to testify to the accident. He's going to testify that it's a suicide, although he does not remember the details. And then all the other evidence will come into the pathologist report, the guy he called to show the body to, the guy who got the threatening phone calls in the jail, and then I assume also the part where he sets the body on fire. And then we would have to say that by clear and convincing evidence, it's clear that having heard all of that, a jury could not convict.
yes, Your Honor, and a note on that standard, because I actually think this is very important.
Yeah.
So I know that the statute, of course, talks about clear and convincing evidence, but it's also talking about whether a jury can convict. And so I think we have to remember the context in which a jury can convict in the first place. And a jury can only convict beyond a reasonable doubt. And so this standard is asking us whether there is enough evidence, if we take it as true that it does say if proven. So if it's taken as true that he had these memories, that these memories are at least genuine.
Yes.
Then-
Not that it happened that way, but
Correct.
that today this is how he remembers.
Correct, Your Honor. So if
Okay.
we take that as true and consider it in light of all of the other evidence, that creates reasonable doubt so that
Just
no
have to say,
reasonable
just
juror-
as a practical matter, and I really struggle with this as a practical matter. His original account, the accident, I mean, there was nothing illogical about it. It was plausible. It's just not obvious to me that a jury would be particularly more moved by someone coming in and saying it was a suicide. I don't have any details, but I can tell you, and we're assuming I genuinely recall that it was a suicide, but all the other physical evidence stays the same. It doesn't actually seem to me.
I have to
It doesn't seem intuitively obvious that, oh yes, now the jury will see everything differently.
I have to push back on you a little
Yeah,
bit
sure.
there, Your Honor. So first of all, one of the things that we have to consider is that there's other corroborating information here. And actually at trial, it wasn't just the case that Mr. Stewart presented what was a plausible theory, because I would agree with that he did. But if we look at the state's closing argument, they actually highlight all of the inconsistencies in Mr. Stewart's accident theory. And so where we switched that, just kind of comparing that one for a moment, when we switched that to this suicide presentation, we actually see other corroborating information. And so we see a note from the victim contemplating suicidal thoughts and depression. We know that this occurred on the anniversary of a forced abortion that she had. And Mr. Stewart is seeking to get more evidence on that. But at this stage, we think he makes that prima facie showing, at least, that it's at least corroborated. But not only does this evidence corroborate Mr. Stewart's theory, it also undermines the state's theory. And we also have to consider all of the Brady allegations or the situations where the state actually withheld information. And so I know that Judge Harris, you talked about, well, there's other kind of physical evidence. That physical evidence is also undermined when we look at the Brady allegations as well. And so I don't think it's a simple situation of, well, now it's a similarly plausible story. We do see a significant change in the evidence here that I think when considering this prima facie showing, just this possibility at this stage, that it is sufficient to make out that actual innocence claim. I do, of course, see that I am over time. I had initially prepared to talk about the Brady allegations as well, but I don't want to overstay my welcome. And so if this court had any particular questions as to that, I'm certainly happy to address it. But otherwise, thank you very much for your time.
Thank you, Ms. Barone.
May it please the court, respectfully request that this court deny the authorization. After a full detailed story about accident in his trial, Mr. Stewart said in 2014 he had some kind of repressed memory that would indicate that the victim actually committed suicide. Now, before I go into some of these allegations that Mr. Stewart has brought forth so far, I want to go back to where we started in this particular authorization process. we objected to the materials that he wished to append to the because much like Shin versus Martinez Ramirez, when we look at the 2254 problem, once you get to that point back in district court, Mr. Stewart would not be able to present these materials to expand the record. And I want to go into that a little bit because this is very important that it's under EDPA. And as this court knows, this court's written several opinions about the limitations in EDPA on federal courts and how they can review things and how they can grant relief. So this comes under the EDPA statutory provisions. And within those provisions are great limitations. And I wanted to put this a bit in context because we're talking about the restrictions in 2244, absolutely. But it is in complement to 2254. And what we know is if you come through all the state system and come into federal court for the first time and you file, let's say, a timely petition and you presented your federal question, what has our Supreme Court told us happens? We don't give him another appeal. We don't look at his question anew. We're looking for reasonableness. We're looking for extreme malfunctions. And that's on first level review. So now we are at 2244, where an individual is asking to come back into federal court again to undermine his state conviction and sentence. So obviously that hesitation has to be there. And that the direction from the Supreme Court, I think, is very helpful when we're looking at application of 2244. Now, the question presented by this court that we briefed on goes to whether recovered memory qualifies as newly discovered evidence warranting authorization to a successive petition, warranting authorization. And our response is standing alone. Absolutely not. Because just that allegation of some recovered memory does not qualify under 2244 B2B in total. One cannot read out everything that is necessary there. And I believe Judge Harris sort of went into that direction a little bit earlier in the argument. It's not simply the factual predicate for the discovery. It's a factual predicate for the claim through the exercise of due diligence. And let's say that you can get through that level. It is not an or after that. It is an and. And the facts underlying the claim, if proven and viewed in light of the evidence as a whole. And here's another EDPA artifact that we need to look at as a whole. Mr. Stewart has suggested that he could go in and give new testimony that, no, this wasn't an accident. This was actually suicide, undefined. We don't have a lot of factual basis for that particular assertion, but that's what he wants to do. That's not what we do in looking at this, because as a whole means his state court record comes with him.
Yeah, but we know his state court record is going to be different because that's the basis for what his claim is. It's disassociative amnesia.
But yes, sir.
Go ahead. In that way, otherwise, we know that.
In 2244, the emphasis on is what the record is today. So you look at the totality of the record. That means his statements, his stories, his testimony will not go away.
I don't
because
see why is this? I really am wrestling with what is the, when we ask about sort of the actual innocence prong of this provision, you know, is there enough there that no reasonable fact finder could convict? It does say you look at all of the evidence and ask, but for the constitutional error, could this person have been convicted? And if the constitutional error in this case, we are hypothesizing, is that he never should have been tried before he had his recovered memory, when he was incompetent. I think we would take out, wouldn't we, the story he gave at trial? Because that is the constitutional error, that he was tried and gave that story when in fact he now remembers it differently. So I think his accident account comes out, doesn't it?
Your Honor, I would say no, because of statutory construction. The construction we're looking at, B2B, talks about factual predicate of the claim. The entirety of 2244 is premised on the claim presented, the claim that this individual wants to raise in a successive action. The claim, and I believe you pointed this out, the claims, two Brady claims and an allegation.
Well, let's assume for a minute now that the claim is that he was incompetent to stand trial.
I would object to.
I know you
that
would,
kind
but
of-
if that were the claim, then how would we do? Then we would take out the accident account,
Well,
right?
We would not, because I
Okay.
do not believe legally you can make that type of a claim. Competency, of course, is determined at the point of trial. And he was evaluated not only by state evaluators, but also he had his own evaluation done. He was competent to stand trial. Whether memories come back in as a portion of a part of B1 for the could not have been previously discovered doesn't make it a claim retroactive to competency.
That's what's kind of hard to read in the thing for me, at least. I mean, to what extent, I mean, if the constitutional error was that he should not have been tried, I see Judge Harris's point. Normally, if you get new memory, it would be, okay, I got new memory, that's going to be considered along with what you said before. You've given inconsistent statements and all that gets looked into. I'm trying to figure out whether that's, and if that's the way you look at it, I think, Mr. Stewart has pretty significant problems proving a reasonable fact finder would, no defense, no disrespect intended, but under that fair scenario, it's a much tougher case. If, however, he's incompetent and therefore you don't get to consider it, he still you have to look at a lot of evidence and it may or may not be enough, but you may not get to consider his other statement.
Well, I see where you're going with the issue. And yes, if he was in fact incompetent, then yes, the trial would be set aside. Had to be competent to go forward. I suggest that wouldn't happen, but if we take that as a premise,
Sure.
That does not eradicate all of his statements and all of the testimony from the other individuals. That's still the case. And that's where we are. And we'll have the DNA on his clothes. We'll have his friend Stanton saying at that time, he said, I flipped, which is consistent with the writing in the jail.
Can I ask you a question? I don't mean to cut you off from that, but I think we have a good understanding of the evidence and can look at that. But here in 2000, Mr. Stewart alleges that he recovered his memory in 2014, and that was raised in two separate state court proceedings, and no evidence was developed there. To what extent does that cause a problem for him, mainly under Shin? I mean, I understand Shin has the exception, but it's really talking about could not be exercised without due diligence. And we now know there's at least some period of time where he had recovered his memory and we don't have more development of that. Is that a problem?
It remains a problem, Your Honor, in two different ways. One is it was a 2014 date that has been connected to that repressed memory disclosure. In 2015, he files a motion for a new trial. In 2016, in front of the hearing, before the hearing starts, he, with counsel, talked about the repressed memories. And counsel says on the record, per their agreement, they are only going forward on two claims, a juror claim and the expert claim. And that was it. That's a waiver. That's a procedural default and a waiver together.
So is your point then that's where Shin kicks in, that we can't develop evidence in federal court when there was an opportunity to do so in state court, but it was not pursued?
I think that is. I think it is also supported by the fact that he tried in 2018 in the PCR, and he didn't present this evidence as he presented it here. Now, of course, we objected. We probably would have objected in state court too. But presenting it in an application for consideration, as we know, doesn't make it part of the state court record. He didn't even attempt that. He's always tied it back to the expert testimony and the Brady violation and the assumption of false testimony, which we say is a mischaracterization. It's a disagreement with that.
Well, and I'm sorry to monopolize, but let me ask one more thing. I mean, we have this issue that's kind of your main point, that he has 3 grounds. You know, they aren't aren't recovery of repressed memory, and we should be kind of formal and stick to the 3 grounds, and this isn't sufficiently connected. This was talked about earlier. You know, we certainly give some deference to pro se litigants, and he spends a bunch of time in his petition on his repressed memory and newly discovered memory. What's the best case you have for us that would say we're sticking to those 3 grounds in a pro se context when there's as much discussion of the newly discovered evidence as there is in this petition?
I think what I would want to rely on, Your Honor, are the claims presented.
I hear you.
That's what he's under an obligation to do. We can't respond to something if he doesn't present it.
Well, I hear you, but he's listed 3 claims, no question about it. But the point they're making is that, hey, there's really a 4th one. It may not have a number 4 under the claims, but a reasonable assessment of that includes that. I'm trying to get at that issue is how do we make that determination, whether to rely on the 3 enumerated claims or whether we look at the whole petition, which talks about the new memory. What's the best authority you have on that?
There are cases, and I don't know if I can remember something off the top of my head, Your Honor, for that particular wrinkle in this argument, but there are cases that say we don't invent the claims for pro se litigants. We can certainly be generous with the claims raised. I would submit to you it's probably a bit of a change from the substance of what we're all arguing. So I don't think it is just being benevolent and interpreting an argument that's been presented. He has consistently said, here's a new theory I want to present, but he has never said anything about competency. And I think it's less case law that restricts the court and more determination of this particular case, because that's what the theory of being generous to pro se litigants is based on. What is he trying to say? And here we have what he's trying to say from 2015 forward. And that is he wants to attack the pathologist report. So I think the focus needs to be on what he's actually trying to say. And again, I apologize for not having it on the top of my head, but I know that I've had discussions even in our district court about the extent to which a court will go to modify a claim. This isn't modifying, interpreting. This would be creating from whole cloth something that this individual has never pressed either in state court or in his filings to this court.
This is not, well, counsel, I don't think this is whole cloth at all. There's been, as you pointed out, there's evidence in terms of the suppressed memory, the amnesia, and the question of being recovered. That's not new. And as to your chance to respond, we ask you, this court, to respond to that question, right? That's why in your brief you address it, correct?
That is correct.
So it's not here today as if it be the first time you hear it. So so it's not whole cloth at all. But the thing is this, it's not the kind of, it's amazing how when we get to mental issues, it becomes so difficult, but we can understand it in terms of bones and flesh. But it's not, to have amnesia doesn't mean you're insane. It's not that kind of competence. The competence would be, first of all, this person, he was allowed to represent himself. Assuming, of course, you disagree, and it has not been shown, but in terms of the dissociative amnesia, he's never been allowed to do that. No fault of the court. This is one of those errors where it's not anyone's fault. And I think that's why it's hard to show your hand around, because it's no one's fault. But you have to look at what happened was, if this is true, then a person who could not have helped he could not have helped his counsel, let alone go and proceed pro se in a trial when he has, and Judge Harris asked this question about amnesia. Normally, a lot of times you just blank it. No, but the evidence, it talks about when an individual suffers from, and this is from the Tracy Thomas, the psychological scientific evidence report. When an individual suffers from dissociative amnesia, memories may cut off from one's consciousness, leaving the individual with either no recollection of a particular event or a fabricated memory. He is the latter, a fabricated memory. Most people think, oh, you don't remember anything. No, but the mind, the brain has an incredible way of defending itself. That's why people become neurotic. I blame all of my faults on somebody else. That's how I get through the day. It's out of control, you become psychotic. Oh, sure, we all have it. And as soon as you said, well, I would have been a great contender if it hadn't been for you. You know, that kind of that kind of thing. But the point is, it filled in the gap with a fabricated memory. So he couldn't have helped his counsel because he's telling, look, I was carrying her, I fell, I was on top of her. That was my defense. That's all he had. That was his fabricated memory. So he shouldn't have been allowed to represent himself. Like I said, let alone he couldn't. So it's not like, oh, now he's trying to say he was insane. No, amnesia is not that. You can have amnesia and do rocket science as long as, you know, you remembered you do space exploration, but you didn't remember a traumatic event. That's different. You're not insane. So that's what Hubbard talks about at this point here. First, is there a statute of limitations on actual innocence claims? Couldn't he bring this again with ask for and then put that fourth one in and another one?
Actual innocence has never been recognized either in the statute or by the United States Supreme Court.
If it's the constitutional, if it's based on a constitutional error,
well,
you're saying it's never been recognized?
Now, this is where I have a little bit of a discussion to have with you on this point, a little bit of pushback.
Go ahead,
because
please.
you were talking about the question that you gave to us to brief was whether recovered memory qualifies as newly discovered evidence warranting authorization. That goes to a portion of the statute, and that's the way it was briefed. Now, as I understand your argument about competency, that he wasn't competent because of a mental illness, essentially, or a mental condition that would have caused some problem. In the state of South Carolina, that does not qualify as some kind of a competency question that would prevent him from going pro se. Under State versus Barnes, it was a capital case out of South Carolina. South Carolina rejected Indiana versus Edwards that would say there's a limitation on pro se determination based on mental health. So we have some issues with.
Also in South Carolina, you could be certified mental illness and it's okay to represent yourself.
Yes, sir.
In a death case.
Yes, sir.
Oh. Well, good thing we got a federal. Good thing we have a federal court. Good thing we have federal courts.
I personally argued against that, but if you'll recall in Indiana versus Edwards, the United States Supreme Court said we'll leave it to the states. The states can consider mental illness, they don't, and South Carolina opted not to, and actually reversed a death sentence and sent it back on that. Because it was the defense that had asked for the individual to be barred from going forward pro se. And we relied on Indiana versus Edwards, the state did in the appeal, and we lost. So had this been a competency, whether to be able to represent himself or to go forward in a competency filing a trial, I think it would have been briefed a tad differently. But the question actually says that the evidence may warrant it. Now, I suppose.
Can I ask you a question? I'm sorry. I just see that we're running out of time, and I did want to ask you a question about this, the Shin issue and sort of procedural complications beyond sort of the provision we're looking at now. I thought that our general rule was that at this stage, prima facie case, is it enough to send it to a district court? Like if there's some honkingly obvious procedural problem, like, well, obviously you're way out of time or something, we might reach it in this posture, but that usually if you satisfy this, we send it back and we let the district court sort of figure out whether they're not send it back. We send it to a district court for a hearing. And at that point, you kind of flesh out the procedural things. And just, I hear what you're saying about Shin. And I think there are some other procedural issues here. But given that there is an actual innocence kind of gateway under the Shin provision, and that's all kind of wrapped up in what we're doing, it seems, isn't this one where we would just kind of send all that to the district court?
Well, it has to be that sufficient showing to warrant further exploration, which when I read that, I don't know whether it'll be a help to the court or not, but when I read that, I sort of equate it to almost a certificate of appealability, whether you have to encourage somebody to go forward on the record. And that leads us right back to the record.
We do have a lot of case law saying that, you know, at this stage, when we're just doing the prima facie thing, we don't usually address procedural complications that might arise. And that we, you know, I know we have that one case that, which of course escapes me, saying, look, you know, I can count 365 days. This is just not worth the time. But this doesn't quite seem like that to me, particularly because the Shin provision has its own actual innocence kind of gateway, which is clearly implicated here. I mean, it's being so.
I see what you mean from Shin. I would suggest that Shin was excuse me if I say Ramirez, because sometimes I say Shin versus K or Shin versus Ramirez. So I switch back and forth with that. But under that case, it's looking at 2254E2. And of course, the first part is the failure to establish the state law basis. So you wouldn't get to actual innocence if there was not an excuse for the failure to establish the factual basis in the state court. So I think my answer would be we don't get there, and it's quite slim. And I'm over time, may I?
Please, good.
Thank you, Your Honor. I think it's very similar to what we look at here. We still have to go back and look at the other evidence in the case, and I wanted to also just touch on really briefly that the other evidence is consistent with what he said before. So it is not just simply his accident case scenario, but what he said to his friend when the body was moved. The fact that the body was burned, if that pathology report can be challenged and say, well, I don't know if I say this is, you know, from the burning or if this is from bleeding internally. Even if we go past that, we still have the burning, and that is destroying evidence. The best evidence that we had of what a pathologist can look at and determine things from the physical side. And also we have the boyfriend, the new boyfriend who testified that he was threatened as well. So we have continuity in the story that was actually told during the calamity writing from the jail. We don't have people saying that she was upset at that particular point in time, very suicidal. The note that he offers in and of itself, we have to look at the context of that. And she does say, I wish I could kill myself, but you wouldn't really care. So here, I let you go. That in and of itself is not a suicide note. So again, we look at the context of the case. And I would rely on the brief for any other point that I might have missed in today's presentation. Thank you, Your Honor.
Thank you, Ms. Brown. Ms. Fontaine-Berry.
Your Honors, and may it please the court, I'm Walker Fortenberry here on behalf of Mr. Stewart. I'd like to emphasize a few points. First, to your point, Judge Harris, this is at this stage, it's only a prima facie showing. This court has applied that test in Ray Stevens as well as Long v. Hooks. So it's just a showing of possible merit. The primary weighing of the evidence is something that the district court does on remand. And I'd like to just emphasize that there's a lot that we don't know here. We've never had an independent pathologist examine the autopsy photos in light of Mr. Stewart's recovered memories. The agent Stuckey's notes as well, those have never been admitted into evidence. And then Mr. Stewart has also requested access to the victim's mental health records. So all of that is something that should take place at the district court level under the rules of discovery.
Could I ask you a question? You know, the consultant, I forget the name, whose report was provided here, who talks about this being a real thing, and I can't rule it in, I can't rule it out. and talks about how I think hadn't had enough time to go further and make a more definitive ruling. And it does the fact that Mr. Stewart, and this isn't a criticism of him or the lawyers because that came relatively late. But if we look at Mr. Stewart, he recovered his memory in 2014. So it seems like there would have been time to do an evaluation. And since he recovered his memory, or requested, particularly given the state court proceedings, where an expert could say one way or another to a reasonable degree of of medical certainty, he's got this. And this particular person may not have had enough time. I get that. But given the fact that he had it in 2014, what do we make of that? Does that present a problem, or do we just overlook that?
Judge Quattlebaum, I don't think so. I think one of the things we are asking for on remand with respect to discovery is a full psychiatric evaluation. As to why we haven't been able to have one yet, I'm not sure the contours of how those diagnoses work. But I know that we do have a preliminary psychiatry report saying that it's definitely possible. And so I think on remand, that's what we're asking for, is a full evaluation.
Yeah, I guess my question is, since the current litigants and experts got involved, they might not have had time. But since Mr. Stewart's had his memory since 2014, as a party, he's had an opportunity and had counsel during that time in certain proceedings. He's had an opportunity to do a more fulsome review and hasn't done it. And now, so we have this thing that, of course, and I'm not suggesting anyone would submit the current report as evidence, it would never get in. But anyway, it just bothered, or I'm just wondering, what we make of the fact that there's years since he recovered his memory where he and other lawyers have elected not to do that.
Well, Your Honor, I believe that the memories start first recurring in 2014, and
Right.
first mentioned the issue in 2015,
Mhm.
and since then has recovered additional memories. And again, I'm not sure how the ins and outs of recovering memories works, but my understanding is that they don't come all in at once, so they may trickle in. So it may have taken him a while to realize, wait, this is happening to me, before he got the first psychiatric evaluation.
Counsel, it seems like this turns a little bit on the statutory language where the factual predicate couldn't have been discovered previously, right? I mean, I guess we're talking about what the previously means, and I no memory for cases at this moment, but I feel like Judge Quattlebaum is raising an interesting question. I think we have cases saying, well, previously means before you filed your first habeas petition. That's the time that matters. Could you have raised it in your first petition? And if not, but then there is this question like, well, how much time do you get to sort of seek authorization for the second one? So I guess this is actually a question. What do we know about the word previously?
You're right. I also don't have the case names in mind, but it is true that the Fourth Circuit has previously held that word previously means since the first habeas petition, and he first filed his
When was that?
habeas petition in 2009. And the memories began in 2014. So with respect to that issue, I don't think that poses a problem.
And also, counsel, you made to your response, perhaps, that the difficulty here, the factual predicate, in most cases, easy because you would say, well, I found the gun and I didn't know where it was, and I found it, and that's when sort of you could have just come in and done it. But it's amnesia, as the experts and some of the literature says, it's a continuum, as you said, it doesn't come back at once. Matter of fact, the experts said, be definitive, sometimes you actually have to see the person like in time, experiencing that type of thing. But the point is that based on his history, it is consistent with this associated amnesia. And I think it's the honesty of the expert here, as opposed to ones coming, well, I know definitively this person is this. No, I'm using science, the truth of science, not just for the purpose of what somebody saying, because so it's a moving continuum as to what is the factual predicate being fully in fruition to be able to say, this time you could have come in and done this. And I think that's one of the problems here, because we're dealing with the mind. But I think that's what the great writ was for when you talk about a situation where a person went to trial, if this is correct, with not even having his memory.
Right, and I think that the nature of the mental illness makes it very difficult. But I would resort to any arguments against slippery slope type arguments is, you have the elements of the statute. Those still have to be met. And I think that's a sufficient backstop. But I see that I'm out of time. If there are any more questions, for these reasons, we'd ask the court to grant Mr. Stewart's pre-filing authorization. Thank you.
Yeah, but let's thank you. Yes, Ms. Stetson. And which please, counsel, stand up. I just want to say that I note that you are court appointed, and on behalf of the Fourth Circuit, we'd like to take note of that. We really appreciate it, and we depend on that. And it is, as they said, as a cherry on the top of it, and to have these incredible law students here, and they well acquitted the Cavaliers today. Well acquitted the Cavaliers. Thank you so much, and of course, Ms. Brown, we thank you for your able representation as well, state of North Carolina. All right, with that, we wish you well and take care. Bye-bye.
Hi, Mr. Kenny, can you hear me?
Yes, I can hear you.
Okay, thank you.
Thank you.
Maybe get this wrong. Jessic,
Jessica, Your Honor.
Ms. Jessic.
Thank you, Judge Gregory, and may it please the court. Zuo Chen requests that the court vacate the BIA's denial of asylum, withholding of removal, and protection under the Convention Against Torture for 3 independent reasons. First, the agency applied the wrong legal standard in holding that Chen did not establish the changed circumstances exception to the 1-year filing deadline for asylum. Second, the agency erred in finding that Chen did not satisfy his burden of proof for withholding of removal or protection under the Convention Against Torture. The agency made erroneous corroboration findings, disregarded evidence relevant to past persecution, future persecution, and future torture, and failed to provide a reasoned explanation for its decision. Third, with regard to protection under the Convention Against Torture, the agency committed legal error by only considering evidence of Chen's treatment in the past without considering evidence relevant to the possibility of future torture, including country conditions. Unless the court prefers otherwise, I will first address the errors regarding the withholding and CAT claims, and then return to the 1-year deadline. The agency erred in finding that Chen did not satisfy his burden of proof for withholding of removal or protection under the Convention Against Torture. The agency made erroneous corroboration findings, but even if the corroboration findings were correct, the court should vacate the decisions because the agency disregarded credible, legally significant, unrebutted evidence regarding past persecution, and future torture. First, with regard to the corroboration findings regarding Chen's mother's statement, the BIA erred in finding that Chen's mother's statement, quote unquote, did not corroborate events.
Can I ask you a special question about the corroboration aspect of this case that I have really been wrestling with, and I'm hoping you 2 fine lawyers are going to set me straight on this. So is there a difference? Are there 2 different kind of sets of opinions here? Is there a difference between an IJ saying, look, I'm crediting your testimony is credible. Nevertheless, I'm requiring certain corroborating evidence. You didn't provide it, and therefore you lose. Is that different from an IJ saying, look, when I look at all of the evidence in this record, I am finding that you haven't met your burden of coming forth with credible, persuasive, and specific testimony. And I am finding that in part because there's certain sort of documentary corroborating evidence that one would expect to find with an account like yours, and I don't see it here. Are those two different things, or is that the same thing?
It sounds to me like you're describing two different things, Your Honor.
Okay, well, which one happened here?
I think the first scenario where the judge.
Okay, how do we know that? Because there's no specific finding that, as we said, there's supposed to be in Wambura, that yes, this is credible testimony. I am nevertheless seeking the following corroborating evidence.
When I read the IJ's decision and when we wrote the opening brief, that was one of our arguments, that there was not a threshold credibility finding.
And why don't you think it's the second category, since there was no threshold finding?
The government in its brief said that.
I know, I don't understand that either.
But that Mr. Chen credibly testified and that the immigration judge did not have any doubts as to his credibility, plausibility, or veracity. And then we would accept that concession. And if it is true that the IJ found him credible, then the IJ had the obligation to weigh the credible testimony with all of the evidence in the record and had the ability and the discretion to require corroborated evidence for certain claims. However, the government only defends the lack of corroboration of the medical records, which are not in the record. And the government defends the BIA's position that Chen's mother's statement, quote unquote, did not corroborate events. I think that's an erroneous finding because Chen's mother's statement corroborated many events. But even if the corroboration findings were correct, the immigration judge did not consider unrebutted, legally significant, credible evidence regarding past persecution, future persecution, and future torture. So that's, I think, where the error is. I think we're in your second scenario where the immigration judge did not comply with his duties to consider all evidence. Because we're talking about the burden of proof, and the burden of proof statute that is analyzed in Wambura talks about in determining whether the applicant has met such burden, the immigration judge shall weigh the credible testimony along with other evidence of record. With the government's concession that Chen testified credibly, we do not have the immigration judge considering other evidence. For example,
but isn't it, counsel? Isn't it? A lot of these cases, we wish we had more fulsome opinions, and maybe this one is another one that we say you just didn't say enough. But isn't it pretty clear reading these opinions that they have the testimony of the petitioner, and he, to satisfy the past and future persecution prongs, he's talked about an event where he was, beaten and jailed and went to the hospital, and the both the immigration judge and then the VA say, okay, but you haven't given us the records, and there's records there. There's a question of, okay, I gave them to my attorney. The attorney says you didn't, and those are, plainly not the sort of corroborating evidence that is not available. And I think that both places they say that. It just seems to me that we're picking this apart to suggest that there's not a finding, that you have not just given enough evidence of this event to satisfy your burden of proof.
Well, there's a two-part answer to your question. One about the medical records. I understand your point, Your Honor. I do believe that the IJ did not comply with the corroboration statutes as explained by the board in matter of LAC because he did not discuss in his decision whether the records were reasonably available to Chen. The testimony is that the records exist but that doesn't mean that they're reasonably available to him. His testimony was that he believed his mother sent the records to his attorney. His attorney says, I don't have them. The implication is that the records are lost. I do think that the judge needs to address that in his decision. The matter of LAC says that the IJ should clearly state for the record whether the applicant sufficiently explained why he cannot produce the requested evidence. And I think it is important to ask the immigration judges to clearly comply with the statute as explained by matter of LAC. Matter of LAC says that the legislative history of the Real ID Act demonstrates that the corroboration provision was enacted in an effort to bring clarity and consistency to evidentiary determinations. So is it enough if an IJ says you should have produced it, you could have, and you didn't? We would submit that that does not comply with the statute.
So if the attorney and or the mother had them, your position, I guess, is that they got lost. So that explains why he didn't produce them at the hearing.
That's the explanation at the hearing. And then the judge's obligation under the statute is to state in his decision whether that explanation is sufficient. But even if the IJ's corroboration findings were correct, the immigration judge only focused on the 3-day detention and the beating.
But hang on, if we're talking about corroboration, why are you skipping past, I mean, there's a question about whether the medical records are reasonably available, and at least we know they existed, and there does not seem to be any clear statement on the record that they were unavailable. But the IJ also relied on the absence of corroboration in the form of affidavits from his fellow church members. And there he said several times, well, of course I can't get those because they'll be persecuted too. And that is consistent with the country reports. And the IJ never mentioned that.
That's correct. And that's one reason that I think the IJ's corroboration findings are erroneous. He uses the same language with medical records to when he's talking about the letter from the pastor. The IJ says, it seems to me you could have gotten a letter from your pastor without addressing any of Chen's testimony or the country conditions evidence that getting the letter from his pastor would have put his pastor in danger. The government does not defend that corroboration finding, which is why I wasn't going to talk about it. I didn't bring it up.
That's fine.
But I do think it does show a pattern in the way the IJ looked at the evidence.
But does it matter, counsel? I mean, I think that's a fair point. I think it's unclear to me from the IJ opinion, the extent to which he did say, it seems like that the minister could have provided it. And then the following paragraph goes back and you could argue he's really relying on the medical records. I can't tell for sure. But when we get to the BIA opinion, you know, the focus is almost exclusively. There is one line near the end where he talks about other events in the church, but you know, the strong basis or the basis of this is the medical record. So does the BIA when you look at the BIA opinion, that seems to, you know, not really be addressing the other issue very much.
I read the BIA opinion as affirming the IJ's holding the lack of the pastor's letter against Mr. Chen, and that was clear error. But the government says that the BIA did not rely on that.
Right.
So I didn't respond to that in the reply brief.
Okay.
The BIA erred in finding, the BIA made a declaratory statement that the Chen's mother's statement did not corroborate events. So both the IJ and the BIA overlooked the corroborating information in the mother's statement. The mother's statement corroborated Chen's testimony that the police arrested him in July of 2008 because he participated in a house church, that police detained him for 3 days, that he was beaten, that he was released after she paid a large fine, and that he had to report to the police each time after he reported he was terrified. And then after he fled to the United States, police often came to her house to look for him and asked her to persuade Chen to come back to turn himself in. Like the IJ in Arita Duras versus Wilkinson, the IJ in Chen's case failed to thoroughly examine the content of Chen's mother's statement. This was error. And I think in the IJ is overlooking the corroborating evidence in
the mother's statement carried to the IJ overlooking other Chen's credible testimony and other evidence. With regards to past persecution, the IJ only focused on the 3-day detention and Chen's testimony that he was beaten. And the IJ actually had an erroneous view of the record. He said that Chen was only beaten one time when Chen testified that he had been beaten during his interrogation and at other times. The IJ disregarded Chen's testimony that during interrogation, the police told Chen to plead guilty to participating in a cult and threatened that he would be in more trouble if he did not plead guilty. The IJ disregarded Chen's written statement that the police kicked him, threatened to break his legs, and instigated other prisoners to abuse him. And upon release, the police coerced Chen to sign his name to a confession and promised to never participate in quote unquote illegal activities again. The government ordered him to report once a week, where police officers threatened to imprison him again unless he identified other members of the quote unquote evil sect in his community. The IJ did not consider that the Chinese government prevented Chen from practicing his religion and did so through coercive means, so the persecution was ongoing. The IJ also did not consider country condition evidence at all in his analysis of past persecution and the likelihood of future persecution. The country condition evidence corroborated his testimony about his past persecution. The State Department reported that the government arrested and detained members of house churches, and that arbitrary detention and coerced confessions were some of the most significant human rights violations. And then with regard to future persecution, this court has said that State Department reports are highly probative of a well-founded fear case. And there were 2 State Department reports in this case, and the IJ didn't discuss any of it. There's no doubt that Chen is a Christian, and the State Department's Religious Freedom Report states the Chinese government tortured, physically abused, arrested, detained, sentenced to prison, or harassed adherents of certain religions for their religious activities, including members of unregistered Christian churches, otherwise known as house churches. So when it comes to the burden of proof, we're not just looking at corroboration, but looking at the credible testimony of the petitioner, all the evidence of record, especially the country conditions evidence, the corroborating information in the mother's statement, and the immigration judge disregarded all of this evidence in coming to his conclusions that Chen did not satisfy his burden of proof, and the BIA affirmed those errors. Regarding the Convention Against Torture, the agency committed legal error by only considering evidence of Chen's treatment in the past without considering any evidence relevant to the possibility of future torture. The agency also committed legal error by failing to address any country conditions evidence at all in his decision. The regulations implementing the Convention Against Torture require that in assessing the burden of proof, all evidence relevant to the possibility of future torture shall be considered. And this includes relevant information regarding conditions in the country of removal. And this court has said in several cases that with regard to CAT, failure to consider country conditions evidence is grounds for reversal. In Quintero versus Garland, this court said country conditions alone can play a decisive role in granting Convention Against Torture relief. And Rodriguez Arias said the wholesale failure to consider petitioner's country conditions evidence constitutes reversible error. In Quintero, this court said even if petitioner has not suffered past torture, that by no means constitutes a sufficient basis for denying his Convention Against Torture claims. The IJ's decision regarding Chen's application for protection under the Convention Against Torture was legally erroneous, and the BIA erred by affirming that decision. Regarding the 1-year deadline, courts have jurisdiction to review questions of law under 8 U.S.C. Section 1252 A2D. In Chen's case, I am out of time.
You may proceed.
Thank you. In Chen's case, the BIA applied the wrong legal standard when it failed to consider that new facts that provide additional support for a pre-existing asylum claim can constitute changed circumstances. The board found that the facts that existed in 2014 when Chen filed his asylum application also occurred previously. And for this reason alone, the board came to the legal conclusion that there was no change in circumstances. The board engaged in no analysis of whether the fact that the police were looking for Chen 5 years after he left China was an intensification of prior threats of persecution or new instances of persecution of the same kind suffered in the past. For this reason, the board committed legal error, and the court should remand Chen's asylum case to the board for proper analysis.
Can I ask you a question about that? What if I think it's actually really hard to tell whether the agency here did exactly what you just said, sort of didn't apply Zambrano and made sort of a legal error, or whether what the agency was doing was applying Zambrano and basically holding that even though new instances of the same kind of conduct can qualify as changed circumstances, these don't. And then that would be a factual finding we can't review. What if I can't tell the difference?
I think that
would I maybe presume the agency did it right? Like we did
Well, I
decide
think-
Zambrano a year before the IJ decision.
That's correct. At a minimum, if we can't tell what the BIA was thinking, the agency didn't clearly disclose its reasoning, and the court should remand the case for the agency to provide additional explanation. But the phrase, thus, there are no changed circumstances, is a legal conclusion because the term changed circumstances has a legal definition.
I mean, I totally hear what you were saying. I will just say, as someone who writes opinions a lot with a lot more time than the BIA has, I'm somewhat nervous about having so much turn on the grammar of that sentence. But I do understand that that is the plainest reading of the sentence. I see what you're saying.
All right.
Thank you.
Thank you. Mr. Kinney?
Good afternoon. May it please the court. I'm Brett Kinney on behalf of the Attorney General. This court should dismiss the petition for review for lack of jurisdiction as to petitioner's claim for asylum, and it should deny the petition as to the claims for withholding of removal and cap protection. As an initial matter, I think it's important for this court to remember that the Supreme Court has recently emphasized that agency decisions in the immigration context are subject to traditional administrative law principles, and specifically the principle that this court and courts of appeals must uphold a decision of less than ideal clarity if the path of the agency's decision-making is reasonably discernible. And I think that resolves a lot of the questions against the petitioner's arguments.
Maybe it's okay if, well, I'm sorry, is it okay if we start then just where we left off, because it'll be convenient on this asylum question? I mean, doesn't it, if you really just take the agency at its word, it does certainly look like the BIA is saying, look, the same thing has been happening the whole time, and thus, per se, that can't count as a change in circumstances. And we did hold in Zambrano that yes, it can. So what do I do with that?
Yes, Your Honor, that was this court's holding in Zambrano, but looking at the text of the agency's, the board's decision, notably in the preceding sentences, the board is discussing the specific facts of the petitioner's case, and then says, thus, there is no change in circumstances, meaning no change here. On these facts, there was no change.
The only fact that they say is that he testified that the police had been looking for him since he left and had never stopped. Thus, there is no change in circumstances. And I don't see how that allows for an argument that the fact that they have never stopped is itself the change in circumstances. I thought they would give up, but it turns out all these years later, they're still after me. That's my change circumstance.
Correct, Your Honor. And notably, the board cited to the transcript from the petitioner's testimony where that was his claim, indicating that it was looking at his specific facts, the specific reason he claimed that he waited nearly 5 years to file.
Right. But what I can't tell, I totally agree with you. And what is hanging me up, and I will let this drop in 1 second, is I can't tell whether they look from this opinion, whether they looked at those facts and concluded that they fall out as a legal matter because there has been no change. This has been more or less static, or whether what they meant to say but didn't say is sure under Zambrano, like the fact that it's been happening the whole time, the fact that it is a repeated instance of the same kind of thing doesn't per se disqualify it. But on these facts, I just don't see any kind of significant increase in the risk here. I mean, you're sort of asking me to assume that that's what they meant. And that, I guess, is where and that's when they said thus, that's what they meant.
Correct, Your Honor. And that's what the Supreme Court has directed the courts to do, is to, if they're reading a decision of less than ideal clarity, and if it's capable of being read to support the agency's decision, it must be read in that way. And that's what the Supreme Court said in Garland versus Ming Dai. And applying that principle here, it's the board didn't say he cannot demonstrate, or the definition of changed circumstances doesn't encompass what he said, which would be an error under Zambrano that the court recognized in Zambrano. And then recently in Garcia Hernandez, this court said that the board had erred as a matter of law in imposing a rule about what the definition of changed circumstances was. That's not what the board did here. They didn't say he cannot demonstrate changed circumstances. They said he did not. And that is a factual question which lies outside of this court's jurisdiction to review. And that's consistent with this court's decision in Gomez v. Holder, which addressed a similar circumstance where a non-citizen said that they initially didn't apply for asylum because they thought conditions in their country might improve, only upon another instance of the same type of harm in the petitioner's home country did that petitioner then apply for asylum. And the agency said that's not a change in circumstances. And this court held that it lacked jurisdiction to consider that discretionary determination based on factual circumstances. And that's exactly what the agency did here, or at least it's reasonably discernible that that's what the agency did. And under Garland versus Ming Dai, this court should deny the petition for review for lack of jurisdiction.
I'm sorry, I think, and I really apologize for eating up so much of your time. Reasonably discernible, I think, means something different. I thought in our reasonably discernible cases, we were saying we can tell which the agency meant. I think you're arguing something different, that even if we can't tell, like I just say, no, could have been either 50-50. You are saying it's not reasonably discernible, but we still have to pick the reading that would have the agency doing the right thing, the legally appropriate thing.
Not necessarily to that extreme, Your Honor, because but in Ming Dai itself, the Supreme Court faulted the Court of Appeals for failing to consider that the agency had found a presumption of credibility to be rebutted. And similarly here,
I'm most definitely considering it. So you want me to apply the reasonably discernible test?
Yes, Your Honor, which the Supreme Court has instructed courts to apply in Ming Dai. And that is a traditional administrative law principle that the court emphasized in Ming Dai. And that also applies to the agency's consideration of the petitioner's claims about withholding removal and for cat protection. It's readily discernible that the agency considered the petitioner to be otherwise credible. The agency did not issue a mixed credibility finding, which was the circumstance in Wambura, where this court could not tell what determination had been made. And notably, while this court has questioned whether there was a threshold determination sufficient with Wambura in this case, the government would submit that Wambura does not require the agency to incant any magic words or follow any particular formula in signaling that it has considered or deemed a petitioner to be otherwise credible. And again, requiring such an incantation of magic words would be inconsistent with Ming Dai, which specifically said that the agency need not follow a particular formula or mechanically incant words to signal that it has made a determination. And in Wambura, this court simply said there needed to be a determination, not that there needed to be any specific facts on the record. Here, reading the decisions, it's readily discernible that the agency considered the petitioner otherwise credible and then required him to corroborate the specific facts of his claim as explicitly provided for in the statute, which says that where an immigration judge requires corroboration, that evidence must be provided unless the non-citizen does not have it and it is not reasonably available. And as it pertains to the petitioner's medical records, he fails at the first part because he testified he did have the medical records. Accordingly, the immigration judge reasonably and counsel for the Department of Homeland Security asked him why weren't they provided? And he said that his mother might have sent them. It was his burden to provide that evidence to support his claim without advance notice from the agency, as this court stated in Wambura in deferring to the board in matter of LAC.
Can I ask you a question about the medical records? So your position is the IJ found his testimony credible. So he's crediting the testimony that he was detained for 3 days and beaten because he was attending these church services. So then the IJ says, but you don't have the records on the nature of his injuries. Why is the nature of his injuries relevant at that point?
It relates to whether the harm that he suffered rose to the level of persecution.
If he's beaten and detained for 3 days because he's attending Christian church services. I mean, we've said you don't need injuries severe enough even to require treatment for it to constitute persecution. And if it comes in combination with being detained for 3 days, you're saying you would need to know more about just how badly he was beaten to know whether he was persecuted?
That is something the agency could reasonably require. And notably, the agency wasn't saying, and the government's not saying that you need medical records in every case. It's just that in this case, was a part of his claim. And the corroboration statute allows for the agency to ask a non-citizen, prove that what you say happened to you. And he said he went to a hospital to receive treatment for his injuries. So then he also said, yes, I have medical records to prove that. But then he couldn't provide those records. And the statute specifically states that where the immigration judge requires corroboration, it must be provided. And
this is where I just get, it goes back to my very first question. Like I could understand an IJ saying, look, I'm not saying you're not credible, but you haven't met your burden because we would expect there to be medical records in a case like this and you don't have any. But once you've already found, oh no, you're credible. I believe your testimony. You were beaten, you were detained for 3 days because of your religion. Like and I know we have cases saying that if you credit the testimony, but you want additional corroboration, they have to go to an element of your claim. So I'm stuck on this once, and this is your position. Once the IJ has said this is credible testimony, I have a concern that the IJ may have been unaware of our case law saying that it doesn't matter what the nature of your injuries are in a case like this.
As to that point, Your Honor, again, in Mingai, the Supreme Court made clear that credibility, persuasiveness, and the burden of proof are separate inquiries. And to prevail, a petitioner must satisfy all three. So even if a petitioner credibly testifies and is persuasive, he can still fail to satisfy his burden of proof. And that's what happened here. The petitioner did not satisfy his burden of proof by providing corroborating evidence, which the statute explicitly says an immigration judge can require. And in this case, there is no argument that it wasn't available. The petitioner said, yes, I have these records. He just didn't provide them or provide any persuasive explanation for not sending them.
There was one other thing that the IJ mentioned by way of corroboration that I just couldn't kind of figure out intuitively. Why does it matter whether the police who came back to their house, to the parents' house to look for Mr. Chen, why does it matter if they had a search warrant? Why was that important to the IJ? I'm guessing there's something going on here that I just don't understand. Why does the search warrant matter?
I'm not sure, Your Honor. The immigration judge didn't further elaborate on that aspect, but I think the immigration judge was just pointing out that the statement doesn't have very many details. It could have been, the immigration judge may have been concerned or wanting to know if this search was a legal or an illegal search, but he doesn't specifically state. But he does point out numerous other details that the letter from the petitioner's mother does not contain.
See, I just wish there'd been more explanation, because that also made me concerned that maybe the IJ thought that, well, if they have a search warrant, this is a legitimate operation. Whereas the country reports would sort of indicate to the contrary, that there's a lot of stuff in China being done kind of under color of law that is nevertheless persecution. And so I understand what you're saying about how much we should require of the IJs, but there were just a couple of things in this opinion that made me really wish we had more explanation for why the IJ thought these particular things, the nature of the injuries, whether there was a search warrant, what import the IJ was attaching to this absence of corroborating evidence.
Well, and the immigration judge, that's simply one example of among many. And again, the immigration judge is issuing an oral decision from the bench. So of course, can't be expected to be as necessarily precise or detailed as panel who has the chance to sit down and go through multiple drafts. But the immigration judge also pointed out how many times the letter doesn't state how many times the petitioner was asked to report to the authorities, when they came to the house, how many times they came. Part of the petitioner's claim is that the authorities have never stopped looking for him. And in fact, that's how he tries to explain his delay in filing his asylum application. But he didn't corroborate that information from anyone, much less the letter from his mother. So the agency permissibly looked at not only the absence of evidence that he testified was actually available, but then the evidence that he chose to submit, which his own attorney acknowledged before the immigration judge, was less detailed than what he would have ideally liked. In addition to the petitioner's point that the agency ignored that he was beaten multiple times, the petitioner's attorney before the immigration judge conceded and stated that he was only beaten one time. And so but all of that is beside the point, because the lack of corroboration is a sufficient and independent ground for denying a petitioner's claims for withholding of removal and cat protection. So the agency did not need to and was not required to reach the questions of whether this harm rose to the level of persecution and whether he had demonstrated a clear probability or more likely than not that he would be persecuted or tortured, because the statute specifically provides that it is a petitioner's burden, an applicant's burden, to carry the burden of proof and to do so and to provide corroborating evidence where it should be provided. And that's what the agency found here. And that's what's provided for and allowed for by the statute. As to the petitioner's arguments that the agency ignored all of the country conditions evidence, this court has explained in the CAT context that simply because there is a pattern of human rights abuses in a country does not demonstrate that any particular individual will be subjected to torture. And that was a key element of his CAT claim, of any CAT claim, is an applicant has to prove an individualized risk of torture. And so without having adequately proved what he feared or what he said happened to him in China, the basis for his claim, he did not have a basis for his claim. And then the country conditions evidence alone was not legally relevant to proving that he specifically would be subjected to persecution or torture.
He says, Ms. K, he says not legally relevant, but then his evidence is that he terms of particularized, he suffered. He endured this persecution because of his religious practice and faith and incarceration. He was beaten. And wouldn't the country report, looking at that and considering that, corroborate that or support that? You said it doesn't prove it, but that adds to the fact that not only he's individually suffered this is countrywide problem. So, I mean, you seem to be very dismissive of even that evidence if it was there.
No, Your Honors. Excuse me.
Go ahead. I don't understand that.
Yes, the government is not being dismissive of the evidence, but simply in accordance with this court's decision in Jadjua versus Holder, which was an adverse credibility case, where the court was looking at to whether the independent evidence, which included membership records in a political party and country conditions evidence, stated that absent the petitioner's non-credible testimony, all that the independent evidence showed was that that petitioner was a member of an opposition party and that members of that party had suffered persecution in their home country.
Right, but that is not this case. You admitted that there's no credibility, adverse credibility finding here. So that case is in opposite to this consideration, isn't it?
No, Your Honor, it's highly analogous in that the credibility.
That case said if you're otherwise incredible, you can't bootstrap it by having a countrywide report to do so. But that's not this case. This case, is there any finding that he wasn't credible?
No, Your Honor, but as the Supreme Court.
Go ahead.
Oh, I'm sorry. I was just going to emphasize that the Supreme Court explicitly stated that credibility, persuasiveness, and the burden of proof are separate inquiries, but they are related. And when a non-citizen, an applicant, fails to carry their burden of proving that what they said happened to them happened, it places it in a somewhat analogous situation to an adverse credibility determination. It's just different ways of reaching the same point that the agency cannot.
It almost sounds like it almost sounds like the game we play with kids. Heads I win, tail you lose. I mean, because you're saying that, well, you need to show this, but if you show it through country, well, that doesn't require it, and persuasion is different. You found him credible. The question that Judge Harris asked you about significance of having the evidence or the hospital report as to the beating. Well, they could have beaten him with a rubber hose, for example, and left no torn flesh or any kind of bone broken. What difference does that make if you found him credible that he was detained for 3 days and beaten? And that beating, maybe let's say he was slapped for 3 days, and all it was there was the brief, as we call it, flush, but the brief contusion of the slap, and it went away, but he was slapped for 3 days. What difference does it make in terms of if you found that to be credible, that you have the medical report? That's what I can't understand. If you find it, I see if you don't believe it, that's something different. But if you find it credible that happened, what difference does that make?
Because those were the specific facts of his specific claim of what he said happened to him. So the agency reasonably and permissibly required him to prove that what he said happened actually happened. And in matter of LAC, the board itself pointed to medical records as types of evidence, which the agency reasonably expects to be provided where they are reasonably available. And so it's not that medical evidence can never be necessary or important. It's just that the petitioner put forward the claim that he went to a hospital to receive treatment for his injuries. And the agency asked, or the immigration judge and government counsel asked, do you have records to prove that? And he said, yes, but did not provide them. And the statute specifically provides that where corroborating evidence should be required, it must be required. And the petitioner did not provide that evidence. And the evidence that he did choose to submit lacked detail and did not sufficiently corroborate his claim. And that fell well within the agency's discretion to determine, and the record does not compel the contrary conclusion. If the court had.
No, sorry, I do.
Judge
have a
Harris has a
question.
question.
Just in going back to the torture point in the case you were citing us to, I mean, I do hear what you're saying about this. I'm really struggling with this one. The court, neither the IJ nor the BIA says what you said. They don't say, oh yeah, we've looked at these country reports. This happens all the time, but that is not enough for an individual to prove his case. They just don't mention the country reports. It never shows up anywhere that what petitioner is describing and what he alleges to be very worried about, should he be returned to China, in fact happens. That this is a problem. And I do take your point that that is not enough to make an individualized showing, but I am concerned. I have actually not seen a case like this where you don't at least get the sentence saying, yes, yes, I've looked at your country reports, but it doesn't show that you personally are going to be tortured. What do I do with that? There's just no reference at all.
I would point the court to the second page of the immigration judge's decision, which is page 40 of the record, where the immigration judge said that he had considered the testimony of the respondent there, the applicant, the proffered testimony of his roommate, and the exhibits. So it doesn't reference the country condition evidence by name, but also I would point the court to the court's decision in No Alaska Figueroa versus Garland, where this court addressed a situation where the petitioner had claimed that the agency didn't address evidence that he said, or excuse me, she said corroborated her claim that she had been threatened by a specific family in her home country. And this court said, yes, the agency never addressed those specifically in its opinions, but that did not matter because that evidence did not corroborate the specific facts of the petitioner's specific claim. Therefore, it wasn't legally relevant, and any error did not warrant reversal.
But this is but the country reports here are so relevant because they do provide some corroboration for the account given by the petitioner, but they also, the IJ does say, I would have expected to see your co-church members to have submitted affidavits in a case like this, and they're not here, and that's a problem for you. And the country reports 100% explain that. The IJ was actually, I think an argument can be made based on the country reports that the IJ was wrong as like two, but you would need some explanation for why, in light of those reports, the IJ would have expected a lot of people to come forward and say, yes, I too am Christian and a member of this home church. And so I do feel like the country reports in this case are relevant.
As an initial matter, I would respectfully disagree with the reading of the immigration judge's decision. The immigration judge did point out that yes, he sort of expected or would think that the church members or pastor would provide evidence, which again is a comment during an oral decision. But then
that's all we have. I mean, it's not
yes,
like there's a written decision to follow. We have to go off the oral decision.
Correct, Your Honor. But and then in the next sentence, sentences, the immigration judge points to thus the petitioner failed to provide corroborating evidence where corroborating evidence could have been provided, such as any medical attention he received, and then about the mother's letter. And then the actual agency decision before review, before this court on review, is that of the board. The board issues the final agency order, and that is the only decision subject to this court's review. And the board did not adopt or rely on that absence. The board, in fact, stated that the immigration judge wasn't requiring additional corroborating evidence, was simply noting the lack of the deficiencies in the evidence that was presented.
Right, including failure to provide corroborating evidence concerning his arrest, detention, or activities as a Christian in China, which, okay. So maybe less relevant to the BIA's decision than to the IJ's decision.
Correct, Your Honor. And in closing, I would just again emphasize that the Supreme Court in Ming Dai has said that even a decision of less than ideal clarity must be upheld if the path of the agency's reasoning is reasonably discernible. And it is from these decisions, and the decisions are consistent with the explicit text of the statute, which provides that the agency can require corroboration, and where it's expected, it must be provided. If the court has no further questions, we would respectfully request the petition for review be dismissed in part and denied in part.
Thank you.
Thank you.
Yes.
Thank you, Your Honor. My colleague has said in argument and also in the brief that the lack of corroboration is sufficient and is a sufficient and independent reason to deny a claim for asylum, withholding of removal, and protection under the Convention Against Torture. And respectfully, I disagree with that. I think that the government is saying that corroboration is an independent element. Corroboration must be tied, the requirement for corroboration must be tied to an element of the case that the applicant must prove. And here, for withholding of removal, the element is past persecution or a likelihood of future persecution because of a protected ground. There's no dispute that it's religion, by the government or by a non-state actor that the government is unable or unwilling to control. There's no dispute here that it's the government. The burden of proof is for the applicant to prove that he's suffered past persecution or has a likelihood of future persecution. There's not an independent corroboration element to proving withholding of removal or Convention Against Torture protection. And the corroboration statute says in determining whether the applicant has met their burden of proof, the immigration judge shall weigh the credible testimony along with other evidence of record. And then it gets into the corroboration statement, where the immigration judge determines that the applicant should provide evidence which corroborates otherwise credible testimony. Such evidence must be provided unless the applicant demonstrates the applicant does not have the evidence and cannot reasonably obtain the evidence. Shall weigh the credible testimony along with other evidence of record. That is where the immigration judge and the BIA erred here. That Chen provided credible testimony that establishes that he suffered past persecution, and the BIA and the IJ ignored many aspects of that testimony. With regard to the Convention Against Torture, there are two legal errors, not just that the IJ did not consider country conditions evidence, but also the IJ only looked at evidence regarding past treatment of Mr. Chen. The regulations require the immigration judge to consider all evidence relevant to the possibility of future torture. And one of those items of evidence is country conditions evidence. And this court has held that the failure to consider country conditions evidence alone in a CAT claim is a reversible error. With regard to the case in Alaska, I think it's important to point out that Ms. Nolasco did not actually have actual knowledge of her persecutor's words or intent. And that's one reason why that's the main reason why corroborating evidence was so necessary in her case, and why this court found in an unpublished decision that the IJ did not err in finding that she did not adequately corroborate her case. And here Chen personally experienced everything that he testified to, except for when the police came to look for him after he left China. Thank you for your time, Your Honors.
Thank you, counsel. Thank you both. Appreciate your arguments. I wish you well and stay safe. I'll ask the clerk to adjourn the court for today, or tomorrow morning, I suppose.
The honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.